mobile. Most human beings can't run 60 miles per hour on their feet. So if you think about the speed at which a phone is traveling, that's going to tell the cell phone company whether it's mobile, inside a building, or outside. If someone is outside, not moving, nothing's obstructing, there's no concrete, there's no rebar, there's no electrical wiring interfering with their phone getting a clear signal to a tower, to the satellite for GPS, that's going to tell them outdoor stationary. And ladies and gentlemen, this is common sense. These are things that you know on a daily basis that you have to deal with your own cell phones. You go into a really tall building, hard to get a signal. You have to go out to a window. And just because that is out there, ladies and gentlemen, doesn't mean that we're saying it's 100% accurate. We're saying that it is reliable on that it is also able to be corroborated by other evidence. What do I mean? 3:18 a.m., where it says the defendant is outdoor stationary, guess what the video at the studio shows? The defendant outside. When it says out here at 4:40 and 4:42, outdoor stationary, guess what the other evidence shows? The defendant outside sending a drop pin to his buddy from that phone. So let's talk about the pawn slip. Again, this goes to showing when you're not.
I'm sorry. It's a good time to do it.
Yes, you're right.
Someone needs a restroom break. We'll take a short recess. Do not discuss the case. Please don't allow anyone to discuss the case. Present certain no research. Thank you. Christine Jose, on your
Yo, what it is, man? What it is? It's your boy Marita Boy back up in this thing, man. Boy, listen. It's getting down to the nitty gritty, man. It's getting down to the nitty gritty. If you're from the South, you know what the nitty gritty mean. That means the bone bristle.
Thank you.
It's getting down to the bone gristle from the root to the doodle. Listen, boy, I know Melly in that thing, shaking like a leaf in autumn, man. Listen, boy.
They're buying phones years before. They're not trying to hide anything at that point. So I submit to you that those are things that are reliable because there's no motive at that point to lie. So we have, again, like I said, she's under the billing for Miss King. So we have Portland Henry. And so if you recall, Detective Moretti talked to you about Portland Henry because it was the question of, it's so weird he doesn't have a phone. Well, you learned that the phone that he had was a pay-as-you-go phone. So it was a minute phone. And you also learned that every single phone call that came into that phone on October 26th of 2018 went straight to voicemail. What's a reasonable inference, ladies and gentlemen? The phone wasn't on. It didn't have minutes, or it was broken. That's what those records show. They don't show Mr. Henry making a ton of phone calls and passing the phone off to someone else. No, they show a phone that was not operating. So looking at the CDRs, so this is from Mr. Demons, the 9807 phone number. What I've done, 840-34 at the top, that's going to be the time that reflects on the records as you can look at them. That's the UTC. So as you've learned, that the difference between UTC, or Greenwich Mean Time, in Florida, on October 26th of 2018 is 4 hours. So that is 4 hours ahead. So to get from UTC time to Florida, you subtract 4. Until November 4th, whether you're looking at the CDRs, whether you're looking at the Facebook or Instagram records, so that way you can help and cross-reference to see what's going on with an individual phone and where that phone is when these messages are being sent and when the social media is being accessed. So if you recall, ladies and gentlemen, we learned that the 805-637-7249, if you see an incoming phone call and then that immediately outgoing to that number, it says it goes to voicemail. So right there, you have at 5:03 a.m., Jamie King calling the phone of Jamel Demons, her son, and being sent straight to voicemail. Then you have an incoming phone call from Frederick Gibbons, Frito Bang, that lasts 491 seconds. You then have another incoming call, only 11 seconds, and then Jamie King again sent to voicemail. So let's talk about the surveillance footage. And I know, I warned you ahead of time, there are some parts of this that are incredibly boring, utterly tedious, but they're important. And sometimes it's the smallest details that show that, look, this is what it says it is. So you have here 3:35 a.m., 36 seconds. And as you recall, this is the camera that sits on 595 on the entrance and exit to the express lanes. We learned from Detective Moretti that the express lanes toll camera all the way out past 136th Street. So ladies and gentlemen, from here, you know from the studio at 3:19 a.m., we're now 3:35, 16 minutes later. We have 2 cars, and you can go and pull this up. And if you need any assistance with doing that, we'll be happy to bring it back up in court and show it to you. You have 2 cars, and you can watch. So if the top lanes are looking east towards Fort Lauderdale, so when you watch these videos, you'll see 2 cars that come here on the eastbound, and then they're going to pop up down here on the westbound camera. They're heading west. And ladies and gentlemen, I submit to you, if you watch these 2 cars, one red, one white, you will see them come up here and go to the left to get onto the ramp over to I-75 South. You can see here the lights going to the Sawgrass Expressway up to the Panther Arena. But if you watch those 2 cars at 3:35.
All right, Philip, I'll start with you. What are your thoughts right now on the prosecution's closing argument, the start of it?
It's very compelling. I mean, when you lump together the ballistics, the digital, the GPS, the phone data, I'm telling you, it's almost irrefutable. In fact, they did not counter it in the defense case. So right now, I think the prosecution is scoring points, and I think Jamel Demons is in some pretty serious legal trouble.
All right, and Megan will give you an opportunity as well. What do you think?
I agree with Philip. The government's doing exactly what they need to do. They're taking the evidence that the jury has seen and tying it together in a really compelling way that's going to refute the lie, the alleged lie that came after the fact that this was a drive-by shooting.
Okay, and we're just at the start of this right now. Philip, I know we have to sign you off. I appreciate it.
All right, Justin. Mike, bring it. Jury entered. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the appearance of our jury, the defense, Dennis, his client, his counsel, and the assistant state attorney. Counsel, if you're ready to proceed with your closing, you may.
So continuing on the pawn slip. Why have a pawn slip, right? Seems kind of silly. But again, it goes back, showing that you're not planning a murder.
In the air.
Yes, sir.
Just keep moving forward. Oh, this one here. Thank you. I'm sorry, go ahead.
When you are not planning a murder, you use your real phone number. And this isn't, oh, this was where I could be reached. He was pawning jewelry. You have this in evidence. And you heard from Amber Allen, who testified that that is the defendant's thumbprint. You have his signature, where he is stating that everything on that document, that the facts stated in it are true. There's a fact. His cell phone number is 772-713-9807. So we go to the Department of Highway Safety and Motor Vehicles records. You have his name, his driver's license number, his signature. The same driver's license number, signature, and name that you have on the pawn slip. Then you have the booking prints, where you heard from Deputy Maycock that yes, he took the prints of the defendant on February of 2019. And that is the same thumbprint that's on that booking print that's on that pawn slip. So let's talk a little bit about the cast analysis. That was the FBI, Special Agent Brandon Collins. He looked at not just one phone, but compared and contrasted two phones in each of these particular analysis slides that he compiled. And those are in evidence, and you feel free to look at those and refer to those. So we have here between 3:20 a.m. and 3:57 a.m. 772-713-9807, Mr. Demon's phone, and the 9081, Mr. Williams' phone, are all tracking together. If you recall, when there's circles, Special Agent Collins is indicating they are using the same cell tower. He's not plotting in terms of the distance on those. That's all he's indicating with that. So this is showing the pattern of travel, that at each of these points, they're using the same cell towers. So ladies and gentlemen, you've learned that the phones of Mr. Demons and Mr. Williams travel in from 3:20 a.m. in 40 minutes.
Like it never happened.
In from 3:20 a.m. in 40 minutes, all the way out to US 27 in Pembroke Road. And so why is that important? You've learned from watching the videos of the geography, how long it takes to get from the studio out to 184th and Miramar Parkway. That's about a couple blocks north of the Sunset Lakes 40th Street entrance. You've learned that. So now you know that how long it takes to go all the way up to Pines Boulevard, because as you've learned, Pembroke Road doesn't go through. You have to go all the way to Pines to get across. So then on the other side, you have Mr. Thomas in the gray Jeep, the deceased in the rear passenger seat, and Mr. Withers, the driver of the red Mitsubishi. And they're both on Sprint. If you recall, Mr. Demons and Mr. Williams, same phones, same phone planes. Mr. Thomas, Mr. Withers, both on Sprint. Because at this point, T-Mobile and Sprint were two different companies. They have since merged. Again, you're showing the same pattern of travel. From the studio, going north up to Sunrise, Sunrise down I-95, 595 across, across to I-75 South Miramar Parkway. And they are showing consistently traveling together. Then we have Francois, track, his phone. Here's his alibi. He's home. This is the Margate, Toscana apartments that you've heard about and learned about. He is nowhere near US 27. He's nowhere near the recording studio. He's at his home in Margate, his apartment, until noon the next day. Then for some reason, at noon, on October 26th of 2018, Jameson Francois' phone is out there in that same US 27 and Pembroke Road location. So is that of Mr. Demons. Very odd location to go to. Nothing out there, except evidence of a murder. And ladies and gentlemen, you know the number of shell casings that were found at that scene. And you know that there's at least A through Q fired into the outside of that vehicle, not including the ones inside the vehicle, in terms of the number of shots that are fired. But they're going back there. So going back to Mr. Demons' phone at 4:40 a.m., remember the timing advance bands. So at this point, at 4:40 a.m., you also have seen the Memorial Miramar video, where at 4:35, Memorial Hospital is right here. At 4:35, 5 minutes earlier, Cortland Henry drives the gray Jeep into the hospital with the 2 deceased victims. So you know where Anthony Williams is, you know where Christopher Thomas is, and you know where Cortland Henry is, because it's on video. So then you have the timing advance band. And again, this goes to, where is the phone? Because the phone, you've learned, connects and talks to the tower no matter what. But the phone doesn't make outgoing phone calls on its own. The phone doesn't send text messages on its own. That takes user input. So here's an example of the drop pin at 4:42 a.m. to Frederick Gibbons. This is from Special Agent Collins, showing where on this red band the phone would be based on the phone network records. Then we have the phone itself saying where it is. Pretty consistent. So let's talk about whose phone it is. And I know it was a lot of video of pictures to watch. I know that. I'm not going to, we all know that I can pronounce 5 countries. So I want to make sure that everyone understands why it's important as to who the phone shows. All of these photos, all of these FaceTimes show the defendant. There's not a single instance that's been put before you in that phone, which is in evidence. It states 64 of the extraction, and then the phone itself as well, that says, hey, this is so-and-so, I'm using Melly's phone. You don't have that, because it doesn't exist. Instead, you have this defendant using his phone. And he's the only person using this phone. And so, ladies and gentlemen, it's important to note that this isn't the polished, perfect shots. These are the outtakes. These are the ones that aren't suitable for public consumption, that aren't put out on Instagram, that aren't put out there to promote an album or anything like that. These are the raw images. That's why it's important to look at those. And ladies and gentlemen, just because there's a photo on this phone of something else, you take a photo of your dog with your phone, it doesn't mean it's your dog's phone. You're taking pictures of what's important to you. I submit to you, you can tell based on these photos and these videos what's important to this defendant. The videos. Just going to play one, but this is, like I said, a sample of the 1,000 Sun. This one is interesting because you see the reflection of the phone in the glasses. The videos also show, if you recall, the video of the Western Union transaction. 772-713-9807, October 2nd of 2018. This is the only individual that is using this phone. Talking about the jail call. You heard about 6 minutes of this call, and of which part there's 2 minutes where it's silent. What is that? You learned during the course of that call that the phone, 772-713-9807, didn't have money to pay for the minutes for the jail call. So ladies and gentlemen, I'm going to remind you what that jail call said.
Hello, this is a collect call from an inmate at Broward County Main Jail. This call is subject to recording and monitoring. To continue, press 1. To disconnect, press 2. Thank you for using security. You may start the conversation now. Hello? Hey, baby, why didn't you just call my phone when I got my credit card? You should have called my phone, baby, because I put money on my phone. It's money on my phone. No, you out of money. I just put my credit card on your phone now. Yeah, oh, yeah, you could have. Oh, yeah, my credit card. Yeah, I don't know your credit card number because it asks for like your expiration date and your zip code. I don't know what your stuff is that's linked to that card. What is 7-Eleven? Like 7-Eleven is around. What you doing, baby? Yeah, I'm riding. My credit card. I'm gonna give you my credit card. Yeah, I'm trying to get turned back your phone because he said I have to answer the phone when I'm supposed to. Yeah, oh, he just said he love you, keep your head up, and everything. And then, yeah, easy. We've been texting your phone. I ain't been reading your stuff, but you got like text messages with him. I didn't know if you want me to call him or anything on three-way or. Call Jeff. Who is that? Hold on. You got your number? Yeah, it's my phone. Jeff. Oh, he did his turn. Okay. Hey, the bridge went up. Okay, GPS is 7-Eleven. Okay, yeah, So I go under contact, I go under justice. Yeah. What's the number? It said I need facial recognition. 762-556. 7. Oh my God, I'm trying to drive, I'm trying to do this. 762-556. Yeah, right here, real quick. I just like, hold on, I'm about to have a writer drive so I can do this for you. But I'm trying to do too many things at once.
So what did we learn in that phone call? We fast forwarded through the part where they're putting your credit card phone number in. They use GPS. They find it reliable to find a 7-Eleven. That's the defendant's phone. Why are you calling my phone? That Mariah is there with Jamie King. That is the phone number that's being called. That's being identified as my phone by the defendant. So let's talk about some of the text messages. And ladies and gentlemen, you will have those to go through and look at them. You'll have the one, and I submit to you that crazy or crazy lady is Jamie King. Go through, read those messages. You can see it's a mother-son relationship. I love you, kid, son. All of those types of endearments showing you who's using the 9807 phone. You also have with Anthony Williams. He's listed as the contact as twin. Ladies and gentlemen, we've gone over the messages where you can see the animosity, that there is some tension between Mr. Williams and Mr. Demmons, where Mr. Williams is making it clear that, and I will fully agree, Mr. Demmons was a talented musical artist. Anthony Williams had not had that level of success. Christopher Thomas didn't have that level of success. They don't have that opportunity because the defendant killed them. But the defendant was making money. He was the one that was the revenue source, the meal ticket in that house. Look at the messages. Look at the tone of them. Look who's asking for money. Look at the way they communicate about things for the house, about food. And look at where Anthony Williams is saying, look, I'm the CEO. The others are artists. Anthony is saying, myself, Mr. Demmons, Mr. Thomas, we're the CEOs. But at that time, Mr. Demmons is the only one who's actually putting in the work, who's doing anything, who's making the money, who's recording the songs. You have the chat with Frederick Gibbons. Ladies and gentlemen, that is the one in which the defendant asked to be picked up from the side of Pembroke Road. That's that drop pin that we talked about in relation to the cast records. That phone is being used by the person who committed the murder. And ladies and gentlemen, the only evidence before you, the only evidence is that the only person that used that phone was the defendant, Jamel Demmons. So go through and look at some of the videos. You have the studio video. You have the brief clip of the documentary. Watch what the defendant's doing with his phone during that. Glued to that phone. Glued to it. So let's talk about the activity and the location data. What does this show? We have on October 25th of 2018, 8:14 p.m., a scent of a CF, or a current location, a drop pin. That one is sent to Anthony Williams. We can look at the messages and look at all of this and verify all of these things. Then the next one going from the bottom up, we have 4:42:49 a.m. That's the first one on the side of 178, just south of Pembroke Road, mere blocks from the hospital. Then we go to the second one, 4:53:30. You can look and you can see, based on the numbers, how close those two drop pins are from one another. Negative 80.38, negative 80.38, 25.98, 25.98. And you can see the time difference between the two of those. And then, this part is key. The next Wi-Fi the defendant connects to is not at his house, not at the YNW Castle, but at Frito Banks. Because, ladies and gentlemen, the defendant committed the murder, dropped off on the side of the road, and then needs to find a way to get home. They can't go home because the other people in the red Mitsubishi, they didn't know what happened, and they need time to get their story straight. And police don't know about Frito Bang's involvement. In fact, police don't find out about Frito Bang and the picking up of this until February and March of 2019, after the defendant's in custody. So what we had to look at now, Frito's house Wi-Fi, 8:47. And then look, it connects back again automatically at 12:27. That further verifies and corroborates the trip back to US 27 and Pembroke Road at noon that I submit to you was to pick up shell casings. Then we go back and we have the one that we did in open court, the one at 6:41 p.m. It is at that location at the video shoot. 10:27 at 3:02 a.m. That is the next time the defendant returns to that house. The YNW Castle, the 18521 Southwest 44th. Ladies and gentlemen, sometimes common sense is not so common. And these details are things that are not being contemplated after the murder. Because if the version that was brought in by Mr. Davis, the defense witness, is to be believed, that phone should have gone to the house. That phone should have connected to the YNW Castle Wi-Fi, not be sending drop pins all over the county and connecting to somebody else's Wi-Fi before finally going back to that house. So remember, that phone showed mobile all the way till 4:03 a.m. That's when it went outdoor stationary. Ladies and gentlemen, I submit to you, that's when that drive-by was staged, and the victims were killed sometime between the highway at Miramar Parkway and I-75 and getting out to US 27. Because you learned they were dead for some time. And look, there's no way to put an exact amount on there, but hearts were not beating when that drive-by was staged. So then if we go into the steps. If you recall, the drop pins, 442, 1,397 steps, 945 meters. And ladies and gentlemen, you can go back, and this is in evidence, you can look through and see when the defendant's at the studio, in the recording studio, you don't see this type of movement. If the defendant was home in bed, you wouldn't have any activity. As to if it's 70 steps, 80 steps, 50 steps, you would have 0 if the defendant was home in bed with his phone. As you recall, 4:03 a.m. is when the phone is saying outdoor stationary inside of Pembroke Road 27. So let's go to Felicia Holmes. Felicia Holmes, I think it is safe to say, hates me. And I'm okay with that. Because my job is to prosecute a crime and prove that it happened. Ms. Holmes didn't show up for a summons. There are consequences if you do not comply with court orders. You were served a jury summons to show up. just as she was served a subpoena to show up. I'm not going to apologize for doing my job. But what I am going to say is remember her testimony. I have to say, the photos are courtesy of Law and Crime, so I appreciate their allowing me to use those. Miss Holmes did everything she could to not perjure herself. Because she didn't want to say she lied to law enforcement. That would get her in trouble. So she was this whole, I don't remember. But even with all of that, she did remember one very important detail. Mr. Demons on a FaceTime call with her daughter. So you know at that point, ladies and gentlemen, that Mr. Demons...
Objection. There's no such testimony. Objected. Thank you. Ladies and gentlemen, you are to rely on your own recollection of the evidence. This is counsel's information of what she believes is evidence. Proceed, counsel.
You heard from her mouth that she heard her daughter scream and that when she spoke with the defendant on FaceTime.
Objection. Same ruling, ladies and gentlemen. You are to rely on your own recollection of the evidence. Proceed.
She was asked if it knew about a drive-by shooting because the cover-up has already started. And remember, Cortland Henry is at the hospital. 4:35. Mr. Demons is not. But they've already worked out this story to try and get away with murder. Whatever was said on that phone call was so troubling and so disturbing to Ms. Holmes that she and her daughter then drove immediately to Broward County. She remembers Frito Benny's house. She remembers lunch. But doesn't remember the contents of the call, doesn't now remember the phone number that was used or anything like that. Doesn't know her 17-year-old daughter's phone number at the time. Ladies and gentlemen, common sense. A mother is going to know her child's phone number. And don't forget, ladies and gentlemen, that little detail about the $5,000 that she got, that wasn't from the state. She says, oh no, that was for a vacation. Ladies and gentlemen, that was hush money. That's what that $5,000 was.
Objection. There's no evidence. Ladies and gentlemen, you are to rely on your own recollection of the evidence. This is argument. Proceed.
So if you recall, Ms. Holmes identified that driver's license in the Snapchat video. That's her daughter, Mariah Hamilton. You can see, again, one of the photos that was previously shown. Ms. Hamilton and Mr. Demons spoke on FaceTime all the time. And Mr. Demons took screenshots all the time. Always making content, whether on purpose or not. Every single time that you can see this is an example of showing this was his pattern. And ladies and gentlemen, remember Ms. Johnson from T-Mobile. The call detail records are just that, calls, not data. A FaceTime, a video communication, is a data usage on a phone, not a cellular telephone call. So you're not going to see a cellular telephone call on the CDR showing Ms. Holmes and Ms. Hamilton's phone call from the side of the road. Javion Glass, the red Mitsubishi. What did we learn from Mr. Glass? We learned that the red Mitsubishi did not stop at the gate. And ladies and gentlemen, that's consistent with the physical evidence, with all of the cell phones, with everything else that cannot be changed by a person's failure to recall, that is in the records, that is on video. That's what you can show to corroborate, to show that he is being honest. Mr. Glass said Mr. Demings was not in the car, that red Mitsubishi, at any point on October 26th of 2018. Same 4 people got in, same 4 people got out. He recalled the different clothing the defendant was wearing at Frito Bang's house. And he authenticated those photos that Danny Polo first introduced, that those were from that evening, where you see Anthony Williams sitting on a couch smiling, where you see Christopher Thomas animated standing up, where you see Jamel Demings doing a handshake with the engineer. And look at those photos, ladies and gentlemen, because if you zoom in and you look up at the top of the one photo where the engineer is sitting down at the computer, Mr. Demings is standing up, you can see the exact same screen grabs of the studio surveillance footage that you watched. You can see the red Mitsubishi and the gray Jeep parked just as they were. So Mr. Glass said that the red Mitsubishi did not stop. Just because you're in a courtroom doesn't mean common sense doesn't apply. If you fall asleep in a car and the lulling motion of the car driving puts you to sleep. That first red light, when you get off that interstate, wakes you up. These are things that you can rely on in your own personal experience to say, oh, yeah, that makes sense. That the red Mitsubishi didn't stop. That the 30 minutes, 30 miles are consistent with one another. That there was no stopping on the side of the road. And also, there's no reason. There is no reason that's been put before this jury whatsoever. Not in the phone records, not in the Snapchat, nothing that explains why 8 people that are going to the exact same location would stop on the side of the road. Just one person would switch a car. No reason whatsoever. And ladies and gentlemen, you can look at those videos and see the cars are tracking together. The phones are tracking together. All the way through until they get to 184. So we have the memorial mirror mark that gives us that timestamp on Mr. Henry. And we also know that here Mr. Henry changed clothes. So we have in short sleeves at the studio, and now wearing long sleeves as he runs in to talk to Officer Amangor, who was the detail officer working at the hospital. So what you have learned from this, but so you know at this point that Cortland Henry has changed clothes. And that'll become important again in a moment. So George Bello, I don't think he has dropped off your certificates and firearms, but I am assured they are coming. You learned that he is part of the Broward Sheriff's Office Crime Lab, Firearms and Tool Marks unit, that he is the manager of that unit, that he has worked in that particular area for a number of years, both here and in Daytona. And you learned more about firearms and how a casing is marked by a firearm, how a projectile is marked. And this is just some of the things that you've learned. Shapes of firing pins, breech face marks, extractor marks, ejector marks, lands and grooves, rifling, the class characteristics, which means every specific Glock 19 has these same class characteristics. The rifling, the lands and grooves, right? Those are going to be the same for each Glock 19. But then you learn the individual characteristics are the things that make each firearm unique. So what do you learn specifically on this casings and projectiles? So starting with the projectile, this was recovered from Anthony Williams. This was from his shoulder. We have the ones from Christopher Thomas, and this is just a sample of the 7 that were recovered. So what do you learn about all of these projectiles? You learn about the projectiles from the Jeep. And again, this is just a sample, not all of them. So you learn that numbers 13, 14, and 15, right? So those are going to be the ones from the Jeep. And the easiest way to reference all of these, ladies and gentlemen, is the G number. The group number, which is the one that's assigned by Miramar, and that's on the packaging for each of those particular items of evidence. So you learn that 13, 14, and 15, which came out of that Jeep, were all fired. 13 and 15 are definitely the same weapon. And 14 is very likely to be the same, but it has too much damage to make a full conclusion. So then on the ones from Mr. Thomas and Mr. Williams. That's the G44, 57 through 63. Again, some of them have both class and individual characteristics, which they could have been fired from the same weapon. And the rest have just class characteristics. And so then we have the cartridge casing. So this casing is at the passenger, rear, driver's side, floorboard. The exact seat Mr. Devins was sitting in a plastic bag. This cartridge casing was found October 26th of 2018. Then we go to November 21st of 2018, where you heard about the testimony they had to use the canine to find these particular artifacts. All these 8 casings are consistent and fired from the same weapon as the one inside the car. From this, ladies and gentlemen, we went through the cantilevers, the lands, the grooves, the rifling on all of those. So we go through every single one. And that's G196 through 203. Right? They all match. And so you learn from George Bello that he doesn't have a weapon for comparison. And he gives a list, 30 or so weapons that could have caused this particular casing and projectile. Right? So you learn that without the actual firearm and the exact same ammunition, you can't do a range of fire or distance determination because there are things in each firearm that would affect that. You want to, in any scientific experiment, make as few variables as possible. If you don't have the gun, can't do it. So then you also learn that if you don't have the gun, you cannot match the casings to the projectiles. You can match projectile to projectile and casing to casing, but you can't match one to the other because there's different marks from different parts of the gun. Other important thing, George Bello specifically excluded Glock firearms because they have a different, very distinct type of rifle. So all of those Glock-related firearm things at Jameson Francois, no relation whatsoever to this case. I can tell you that was not the murder weapon. Can't tell you that what specific gun was the murder weapon. Because it's never been found, there's never been another match to that to this day. So let's go to GSR. Tara Helsell came in and testified from RJ Lee. You learned GSR primer, that's what she's testing for and looking at under the scanning electron microscope. Antimony, barium, and lead. That those three, when all three are together, are considered GSR. That is a gunshot residue particle, all three of them. You learned that Mr. Henry has one 3-component GSR particle on his left hand. And then there are 2-component particles, so either lead and antimony, lead and barium, or barium and antimony, right? One on his left hand and one on his right hand. So you've learned that some of those maybe show up, the 2-component particles, in other circumstances. But generally you see a third element. I believe she referenced brake pads, and you could also see steel. You don't have that here, right? So you have a 3-component GSR and a 2-component GSR, 2 of those. So the G in 2023, you then have more than 9 2-component GSR particles found 5 years later. They're still there. And that you heard from Chris Williams, who obtained those during the shooting reconstruction, sent them in for testing. So what does that tell you about Portland Henry? Ms. Kelso was very clear. She goes, I cannot say that GSR being there or GSR not being there means that someone fired a gun. Because there's 3 options. 1, they fired a gun. 2, they were in close proximity to someone that fired a gun. Or 3, they touched a surface upon which GSR was and it transferred to their skin. So ladies and gentlemen, with regards to the GSR, you also learned that it falls off very quickly. So you have a Jeep covered in 2-component particles, and you have Mr. Henry having 1 after changing clothes. What you don't have is an answer as to Mr. Dennings, because he was never tested. Because he didn't speak to law enforcement that day, he didn't go to the hospital, he was never tested for GSR. He did nothing on that. So you can't draw a conclusion one way or the other as to GSR, because there is no answer to that. So again, George Bello says all 8 casings are all from the same firearm. You can't have a drive-by, have a casing right up inside the car. Doesn't work that way. So then we get to Mr. Henry's statement. Part of the cover. So you hear I was getting sleepy, I was almost home. Out of nowhere, I heard gunshots. I ducked down, almost crashed the car. And these are from that sheet that you had. And if you want to listen to that statement again, those will be made available to you as well as the disc, but you would have to come out into the courtroom to look at those. So he's talking about ducking, hitting the median. He's embellishing, trying to sell this story. Because there's no evidence that shows any sort of tire damage, any sort of rim damage whatsoever. But no description, no idea what type of car, nothing on that. Because there wasn't one. But he is trying to build a cover story to take this defendant and separate him from the shooting. So as you learned, how Miramar Parkway is laid out. And you learned that the Miramar Police Department shut down Miramar Parkway and walked more than 2 miles. They walked from I-75 all the way to 184. And so when you look at Miramar Parkway and the geography of it compared to Mr. Henry's statement, it's interesting to note that the hospital is right there. If it happened as he stated, we wouldn't have differing time frames on the postmortem wounds and the fatal wounds. That's a mile. From I-75 to 172nd, 1 mile. From 172nd to Pembroke Road, 1 mile. If that's where this happened, you would have evidence of it, and there is none. There's no casings, there's no blasts, there's no projectiles. So from this, all the cell phone records show consistent path of travel all the way across Miramar Parkway to 184th. That is when everything splits. If you recall, Detective Hector Bertrand testified when these maps were placed into evidence. So let's go to the DNA. On October 26th of 2018, Chris Carter swabbed the rear driver's side door handle interior. It wasn't tested until later because, ladies and gentlemen, as you can tell, investigations are fluid. They evolve. Let's not also forget we had 15 months of a global pandemic when nobody came into this building. So this isn't tested until later on. Doesn't change what's on the swab. As you've learned from both Kurt Rhodes, the DNA expert, if you have DNA on there and it's in an optimal environment, like a cotton swab, it's going to be there pretty much indefinitely. On this swab, when it is tested, from this door handle with the blood on it, here's what you have. Very strong support for Christopher Thomas. Limited support that Anthony Williams is also included. And very strong support that Jamel Demons' DNA is on that door. So, ladies and gentlemen, when an item is tested, it doesn't change the results. There are many factors that go into when an item is tested. Witnesses aren't being cooperative. Have to come up with a different way to prove it. This is the other way to prove it, ladies and gentlemen. That his DNA was on that door handle. Let's go to the trace evidence. This is a very unique evidence that you don't see very often in any case. And what does the glass on US 27 and Pembroke Road tell us? Let's think about this. The glass is on the north side of the road. Why is that important? So if you have Melly's murder mobile on the south side of the road, stage the drive-by, you now have a ton of shattered glass. Some in the vehicle, some hanging on. You have to leave that area. How do you go from facing eastbound on the south part of the road to going back to US 27, because that's the only way out, as you've learned, pop a U. What happens when you pop a U-turn? All the glass that was in that vehicle is then thrown out to the north side of the road as they make that U-turn. So, ladies and gentlemen, that's why this glass was collected, and that's what it shows. It shows the pattern of travel and the fact that this did happen in Miramar on the south side of Pembroke Road. So you have the different populations of glass, and you heard from James Morano that the two different types that he went through and he compared them, and that they are consistent, both the standards as well as the ones on the side of the road. It's another thing and another level of showing you that this Jeep was out there, that this was the cover-up, that this was not a drive-by. So let's go to the gangs. And ladies and gentlemen, I'm limited on time in terms of what I can talk about. So in some areas, I'm going to be brief. This is one of those. Ladies and gentlemen, the evidence clearly shows the defendant is a G-Shine blood gang member. And so for the purposes of the jury instructions that His Honor just read to you, you have to determine if at the time of this offense, if the murder of his two friends benefited the defendant. And in benefiting the defendant and promoting or benefiting his position in the gang, it then helped the gang itself. You learned many, many things about G-Shine, the organization. And I think the most important thing to look at is to compare and contrast the public-facing, the YouTube videos with the gang signs, the music videos, the motto for the album, right? Those could be an actor. That could be a show put on for the public. But look at the private side, the not for public consumption. Look at those messages. And look at that, there is a benefit to both sides. The gang gets notoriety, gets money. The defendant, he gets access to different venues. He gets protection. He gets a sense of whatever you want to call comes along with being a gang. And so, ladies and gentlemen, you've heard lots of testimony from Detective Danny Polo as to what the primary activities of G-Shine, of GKB, Gangster Killer Bullets, are. You learned that they're the enforcers. You learned that they are violent. You have that information before you in those text messages. The nighttime drive. This shows the conditions under which this murder took place. This is not an area you find by accident or misfortune. This is a planned drive out to the edge of the Everglades where there's not going to be any witnesses. This shows pre-planning and premeditation. This is a consistent, quick, no stops, no detours ride out here. And so some of the things that you can look for premeditation, the nature of the weapon used. So having the firearm already. And ladies and gentlemen, how do you know that they had the firearm already and the defendant had the firearm already? Because he asked for it the day before. Remember, on October 25th, Jamel Demons, 9807, sent a text message to Anthony Williams asking, where's the firearm? FYE. And Mr. Williams says, it's in here with us. And if you look at the context of the conversations, that shows they were driving down from a location in Stewart, and they were driving to pick the defendant up at the airport. Mr. Williams brought his own murder weapon to the defendant. Look at the rest of the conversations. There's multiple discussions about this firearm. Where's the firearm? From Mr. Williams to Mr. Demons earlier on. It's in my closet, third shoebox. This is discussed. That is not a lighter. That is not a really great song. That's a firearm, ladies and gentlemen. There is discussion about firearms. The presence or absence of adequate provocation. When you look at that and you're looking at this case, they were friends, right? They were buddies since they grew up. But look at the stress being placed on this defendant as the only one bringing the money in, as the only person who's paying the bills. Look at the tension on that, right? Look at the issues and concerns with Mr. Williams, Anthony Williams, and the defendant's mother. that they're fighting an argument. The message is on there to that effect. So look at, for premeditation, you can also look at the manner in which the homicide was committed. Anthony Williams was shot in the back of the head. That was planned for when he was sleeping so that he could not fight back. That was a premeditated, planned killing of Anthony Williams, where there would be an alibi already discussed. So then, Christopher Thomas. Premeditation, as the judge instructed you, does not require days, weeks, months of planning. Premeditation can be formed quickly. Example we used in jury selection. Going to your mom's house on Mother's Day. Forget to bring flowers. You reach down, pull some flowers out of her yard and give her to those. That is premeditation. That is thinking about something, then doing. Ladies and gentlemen, I submit to you the murder of Christopher Thomas was premeditated in that as well. Chris Thomas, as you saw with Sergeant Williams and Mr. Howard demonstrating, oh my goodness, what's going on? Mr. Devins then made the decision at that point, he couldn't have a witness. So look at that. Those are all things in which you can get premeditation, how it was committed, the wounds that were inflicted, the back of the head. Going to Facebook. Showing again that the different information that you have before you belongs to this defendant. 772-713-9807. And that Melly, Montana at iCloud.com is the email. Remember the snapshot? Melly.Montana. These are names that the defendant uses over and over again to talk about and communicate and identify himself. And look, that phone says verified as belonging to Jamal Devins. Also remember Facebook. We have October 26th of 2018. Sun's going down. And the defendant's phone also shows him at this location in Cocoa. And he is dancing and singing and performing, wearing the same jacket, an identical jacket to what Chris Thomas was wearing the night before, and showing Mr. Henry wearing the denim jacket, like Mr. Williams was wearing the night before. And so the question was posed about a contractual agreement and losing money to be there. Well, ladies and gentlemen, look at the text messages between Mr. Devins and his mother, because he wasn't worried a couple of months before about missing a show because he was getting his hair braided and losing $1,000. But then this night, when his friends were killed, he's dancing and partying around and is worried about a contractual agreement. Just look at those types of information and those types of behavior and how someone is acting. Snapchat. You recall, this is the argument between Mariah Hamilton and Jamel Devins, Melly, Montana. Court coming everywhere with me, because if them crackers can grab him, it's my fault if you forgot. I keep Portland with, because at the end of the day, he did one of the realest shit in my life. Yeah, he covered up a murder. Did a very terrible job of it, but that's what he did. That's what this is referring to. This is less than 2 weeks after this homicide occurs, and that's what they're talking about. Ladies and gentlemen, you have a confession in this case. The defendant, and now look at the time. Remember we talked about the UTC? So subtract 4. So UTC 2,000 hours, you subtract 1,600 hours, you do the conversion, so 4 p.m. 4 p.m., I did that with the smiley face. And that's when I said in opening, context is key. The whole floor is coding. Awesome if you work at Google. Terrible at Broward General Hospital. Context is key. So you've learned Easy Gambino, as you heard from Detective Moretti, eventually facing federal firearms charges, gun dealer, is told by the defendant, I did that. Shh. And look at the messages between Mr. Demons and Mr. Gambino. Easy Gambino is a blood gang member. Uses all those same information, slang words, changing of the letters that you learned about from Detective Polo. October 26th, he asks and reach out to see how the defendant's doing. And the defendant says, I did that. And to make a spelling that, other times he uses DAT. And gentlemen, you saw the song where he has a song that he's released called THAT in his phone. So again, Instagram and how these all fit together. 6:58 a.m. Jamie King, RN, the defendant's mother. Are you here? I'm in Miami. And by the stadium, I'm a mess. I'm so worried. I'm here. Remember those CDRs where you have sent her to voicemail? Ladies and gentlemen, this shows that she's trying to contact her son. He is ignoring her, and so she's reaching out to her son, who responds back with, I love you, Mom. I'm good, Mom. Because he had the phone at that point. So the judge read you the law. Anthony Williams is dead, and it was premeditated. Ladies and gentlemen, I submit to you the evidence very clearly shows the defendant was caused by Janelle Demons. Same as to Christopher Thomas. Talks about premeditation. Principles. So if, ladies and gentlemen, if you believe that Cortland Henry is charged, but that's for another jury on another day. If Cortland Henry assisted and helped and shot these two individuals to help out Mr. Demons is just as guilty. Because a principal is someone who decides to help before the murder is completed. And you have that with Mr. Henry in making that drive and going out to the edge of the Everglades. You have that. He is a principal to first-degree murder. Mr. Demons is just as guilty, and so is Mr. Henry. So, in my few remaining moments, I want to briefly touch on the unlucky 13, because I'll give Mr. Adelstein, Mr. Henry. He's charged, right? So, from all those unlucky 13 people that are listed as suspects, they have one thing in common, and only one thing in common. They made a single online threat. In poor taste? Yes. Any other evidence that ties them to this case? None. No location data. No communication from anyone in that Jeep to say where they were. No DNA of any of those people on that Jeep. No ballistics evidence at their feet where they were sitting in that Jeep. No private confession. Because remember, all of these online threats, they're out there for the public because they're trying to get attention and trying to get some sort of benefit for that for themselves. Distasteful? Yes. A crime? No. There's no drop pins for an emergency pickup from any of those individuals. There's no phone for any of them at any of the scenes in this case. So, motive. We talked long and hard, but we don't have to prove motive. Motive, it's intent. Intent is an action of the mind. So I'll give you motives. Anger, greed, resentment, advancement in the game. You heard $16 million was coming into Jameson Francois, and that you saw $15,000, $10,000 payments going to Mr. Demings. Simple math. Splitting something 4 ways or 2 ways with Mr. Henry, who wasn't smart enough to even properly give a statement to keep Mr. Demings away from the car. So we have all these pieces of the puzzle that we have just talked about. And each and every one shows how this case has been brought together, shows the physical evidence. And so, ladies and gentlemen, there's no murder weapon, right? The question that you have to answer, and that you can now answer based on all of this evidence, is that Jamel Demings was sitting in the back seat of that Jeep. And he was the one that fired the fatal shots that killed Christopher Thomas and Anthony Williams. And you know that because even if you choose to disbelieve one part of the evidence, 2 parts of the evidence, you can see what the overall picture is. The overall picture puts Mr. Demings in the back seat of that Jeep. It puts him holding a gun. You don't need a murder weapon to know that he committed these 2 crimes. Ladies and gentlemen, I would ask that you serve justice, that you deliberate, and that you return a verdict of guilty as charged as to murder in the 1st degree. Thank you.
Mrs. Johnson, sorry, what was it? The case is not being turned over to deliberations at this time. The same admonition I gave you before, and every time the rule remains in full force and effect, you are not to discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. And certainly no research. Just leave your notepads on your chairs and all those your instructions. And we'll see you back in an hour, 15 minutes. All right, so we'll see everybody back at, let's say, no later than 1:30, all right? Thank you. Nice one. Anything else to discuss this time? No, sir.
Yeah.
All right, see everybody back at 1:30, all right? Yes, sir. Fair 1:30. Thank you. Have a nice lunch.
Red Mitsubishi and the gray Jeep parked just as they were. So Mr. Glass said that the red Mitsubishi did not stop. Just because you're in a courtroom Doesn't mean common sense doesn't apply. If you fall asleep in a car and the lulling motion of the car driving puts you to sleep. That first red light, when you get off the interstate, wakes you up. These are things that you can rely on in your own personal experience to say, oh, yeah, that makes sense. That the red Mitsubishi didn't stop. That the 30 minutes and 30 miles are consistent with one another. That there was no stopping on the side of the road. And also, there's no reason. There is no reason that's put before this jury whatsoever. Not in the phone records, not in the Snapchat, nothing that explains why 8 people that are going to the exact same location would stop on the side of the road. Just one person would switch a car. No reason whatsoever. Ladies and gentlemen, you can look at those videos and see the cars are tracking together. The phones are tracking together. All the way through until they get to 184. So we have the memorial mirror mark that gives us that timestamp on Mr. Henry. And we also know that here Mr. Henry changed clothes. So we have in short sleeves at the studio, and now wearing long sleeves as he runs in to talk to Officer Amangor, who was the detail officer working at the hospital. So what you have learned from this, and you can watch it again, they first bring in the body of Anthony Williams, who's that front seat passenger. Then they, in the pictures you can see from the Jeep at the hospital, they then recline that seat all the way forward to take out Mr. Thomas, and they bring Mr. Thomas into the hospital. I'm not going to play the video now, but so you know at this point that Cortland Henry has changed clothes. And that'll become important again in a moment. So George Bello, I don't think he has dropped off your certificates and firearms, but I am sure they're coming. You learned that he is part of the Broward Sheriff's Office Crime Lab, Firearms and Tool Marks unit. That he is the manager of that unit. That he has worked in that particular area for a number of years, both here and in Daytona. And you learned more about firearms and how a casing is marked by a firearm, how a projectile is marked. And this is just some of the things that you've learned. Shapes of firing pins, breech face marks, extractor marks, ejector marks, lands and grooves, rifling. Their class characteristics, which means every specific Glock 19 has these same class characteristics. The rifling, the lands and grooves, right? Those are going to be the same for each Glock 19. But then you learn the individual characteristics are the things that make each firearm unique. So what did you learn specifically on this casings and projectiles? So starting with the projectile, this was recovered from Anthony Williams. This was from his shoulder. We have the ones from Christopher Thomas, and this is just a sample of the 7 that were recovered. So what do you learn about all of these projectiles? You learn about the projectiles from the Jeep. And again, this is just a sample, not all of them. So you learn that number 13.
All right, we're going to jump out of this for a quick commercial break, but I'm also learning court is now on their lunch break, which means our lunch Q&A will start as well. When we come back, Anjanette Levy will take over for the question and answer session with our law and crime legal guests. So get your questions ready for social media. We'll be right back.
They say seeing is believing, but with Stearns & Foster, that's only part of the story. We handcraft every Stearns & Foster using the finest materials like indulgent memory foam and ultra-conforming IntelliCoils for a beautiful mattress and indescribable comfort every single night. Stearns & Foster, what comfort should be.
Get a $300 instant gift with the purchase of select Stearns & Foster mattresses at Mattress Firm. Shop Mattress Firm, in-store and online today.
Thanks for joining us here on Law and Crime. I'm Anjanette Levy, and we will be taking your questions during the lunch hour in the YNW Melly double murder trial for the next hour. So keep those coming to us on YouTube, Twitter, Facebook, TikTok, Instagram, and Threads, and we'll get to as many of them as we can. We are there, folks. The state has ended its closing argument, the first portion of its closing argument in the YNW Melly double murder trial. So the defense will begin its closing after the lunch break. YNW Melly, of course, legally known by his name, Jamel Demons, his birth name, is facing 2 counts of first-degree murder for the murders of his 2 friends, Chris Thomas Jr. and Anthony Williams, back on October 26th of 2018. If he is convicted of first-degree murder, he faces a possible punishment of death under a lower threshold signed into law earlier this year by Florida Governor Ron DeSantis. His co-defendant, Cortland Henry, will go to trial later this year in October.
So as I mentioned, we will be taking your questions for the next hour until the lunch hour concludes. So keep them coming to us. With me to talk about this case and to answer your questions is Terry Austin. She is down at the Broward County Courthouse in Florida. Also with me is Brian Buckmeyer, an attorney and host here at Law and Crime, and Offie Patterson. She is an attorney as well out in California. But Terry, I want to start with you. What was it like during closing arguments in that courtroom this morning?
Well, Anjanette, first of all, that courtroom was packed. It was hard to get a seat. I think both sides wanted to make sure they were there for those closing arguments. And this morning, we heard from Judge Murphy. He gave all of the jury instructions to the jury. Most of them were standard. He defined for that jury what is premeditated first-degree murder, and he defined also manslaughter, which is the lesser included charge, so they could understand the difference between those two. And I will note that we were wondering whether or not he was going to do that felony murder charge, and he did not give the felony murder charge. So it's just the first-degree murder, premeditated, and also the manslaughter. Then after that, it was a very short, not even a break, basically a minute. And the judge said, okay, are you ready? And Ms. Bradley got up to do her closing argument. I will say, I do think, Anjanette, it was succinct, it was organized. She went through all of the evidence and she stated that the motive, which she said she doesn't have to prove, and she does not, she stated it was greed, and that most of the motive had to do with money and resentment, that she believes that Melly was feeling as though he was carrying the weight of that YNW Melly, the whole collaborative, and he was doing all of the work. And this is the motive she's stating for the shooting. So very interesting. She definitely went through all of the evidence, the gun, the DNA, the investigation, the drive, and she did it fairly well. And I thought that it was not too long. And you could hear a pin drop in that courtroom, both during the jury instructions and absolutely during her closing argument. And as you said, Jeanette, we will hear the closing argument from the defense team when we return.
And we want to take a look, Terry, very briefly at a clip from the closing arguments, and then we'll talk about it on the other side. The red Mitsubishi. What did we learn from Mr. Glass? We learned that the red Mitsubishi did not stop at the gate. And ladies and gentlemen, that's consistent with the physical evidence, with all of these cell phones, with everything else that cannot be changed by a person's failure to recall, that is in the records, that is on video. That's what you can show to corroborate, to show that he is being honest. Mr. Glass said, Mr. Demmons was not in the car, that red Mitsubishi, at any point on October 26th of 2018. Same 4 people got in, same 4 people got out. So there was Christine Bradley in closing, just a small portion of it. She's using the puzzle piece analogy, that a lot of these prosecutors use in a circumstantial case, where they say, all of these puzzle pieces are going to come together and it's going to paint a picture for you. Terry, I want to ask you about another thing just really briefly. There was an instruction that Judge Murphy read to the jury where I guess the jurors are going to be able to consider manslaughter as a lesser included offense in this case, which was that surprising to you?
It wasn't surprising because there was an argument before about including that manslaughter charge, and the prosecution actually asked for it. And to me, it signals they want to make sure they cover all their bases. The defense did not object to the manslaughter, so they both on each side think that there's a possibility, I believe, that they could have that lesser included. I think at the end of the day, it depends on how you think the evidence went in. If you want that jury to have something else to look at, if they don't come back with that first degree, I think that helps the prosecution. So it's in there and, it's there for them to consider. And the judge gave the definition and the difference between that first degree premeditated murder and the manslaughter, where you're not intending absolutely that they're going to, end up being premeditated. So that's what he ended up doing.
Brian, I wonder what you think of that, because it seems like a big leap from first degree murder, death penalty, possible punishment, to a lesser included of manslaughter.
Yeah, it doesn't make a lot of sense when you're going after that top charge and you're looking for the death penalty. But from the broader concept of we want to make sure we get him on at least something, I think it's more indicative of showing that the prosecution says, hey, there's a chance we can lose if we go for the ultimate punishment. So let's make sure that we have other options for the jury. She spent a very good amount of time, and I think she did a very good job, Prosecutor Bradley, in describing what premeditated was. The analogy of you forget your Mother's Day, and you go and you pull roses or flowers out just as you're approaching the home. That made sense, but I think for a case like this, and maybe why the defense didn't object, either you believe he did it or you don't. I don't think it's going to be a lesser included type of case.
Afi, what are your thoughts on this?
So I've been watching the prosecutor this morning, and I think she's been doing a solid job. I think that she is finally putting all the crumbs together that she's been piecemealing us. And I think she's definitely delivered a hot pie of conspiracy. I think that there's been just really good evidence that's been presented, which is the phone evidence. And for me, what was interesting was she pointed out the fact that there was definitely somebody in the car when Juvie and Zach were murdered. Who is that person? I think she did a great job presenting the evidence that there was nobody likely on that highway that night that could have gotten in the car. And I just think that, with respect to first degree murder or manslaughter, I think Brian said it, you either believe that he did it or he didn't. I think that the manslaughter was put in there. It's kind of like you can call it a catch-all if you want, or a backup if you want.
Yeah, it makes me wonder if maybe they think, okay, they're drunk and high and they're partying at the recording studio. He and Cortland fall asleep, and maybe something happened in the car and he didn't intend to do this, and it was an unintentional thing, but still did it. I wonder if they think the jury can reach that type of conclusion with the evidence that came in. Terry, let's get to the questions now. And Terry, this one's for you. So tell us a little bit about the schedule. It comes from Scully Wolf from YouTube. Is this the last day?
Well, this is the last day as far as anything going to that jury. They're going to hear the rest of the closing from the defense, and then they'll hear the rebuttal for the prosecution. The defense will get 3 hours, and then we'll hear from Christine Bradley, who does the rebuttal, and that will be 1 hour. And after that, we've already had the charges, so there's nothing left for this jury to hear. The judge will then hand the case over to the jury for them to begin deliberating. That will probably occur in the morning. It could occur this evening, but they will get the case and then they will begin their deliberations. My understanding is that today or Friday, once they start deliberating, they will end at 5:15. So if they end at 5:15 tomorrow's Friday, then they will, and they don't, let's say they don't have a verdict at that point, then they will stay over because they are being sequestered this weekend at the hotel. And we have been informed that they will come back. Let's say they don't have a verdict Friday evening at 5:15. They will come back on Saturday and they will deliberate here in the courtroom. They're only allowed to deliberate in the courtroom. And they could have questions. If they have questions, they ring the bell once. If they have a verdict, they ring the bell twice. And so we could very well be here over the weekend as well.
Could be a long weekend for that jury. Only they know where they will go with this. Brian, our next question is for you from Daddy Bars from YouTube. In this case, who would benefit more from a hung jury, the defense or the prosecution?
So let me put it the other way around. I think the prosecution will benefit in this, and this is why. If there's a hung jury, I think it's 100% chance the prosecution is going to want to retry Melly. And oftentimes, most people will tell you that the second trial, oftentimes a prosecutor has a greater advantage because a lot of the defense arguments that are made in the first trial, they're prepared for it. The defense's greatest strength in any case is the element of surprise. The prosecution has their case. They don't see the holes in it the way that the defense does. And so the defense pokes those holes. But they go to a second case, the defense can't poke the same holes. They got to find new ones because the prosecution has then strengthened their case. So if it is a hung jury, I think it benefits the prosecution because of what will ultimately happen in that second trial.
Yeah, they basically get a do-over. You know, they get to see how it comes in, how the evidence is attacked, what the weaknesses and the strengths were of the presentation. So you just don't know when it comes to these things. All right, our next question is from Miss Duchess Florida, FLA, and it's from Twitter, Offie. The judge said the jury could charge him with manslaughter instead of first degree, in which he was charged. Is that normal to give the jury the option to choose a lesser charge?
Yeah, it absolutely is normal. It's called a lesser included offense. So you always want to charge the defendant with the highest charge that you think you can get a conviction for. But there is also, I hate to call it a backup, so to speak, and you can get those lesser included offenses in there, and that's what manslaughter is. Something that I found so interesting and important during the jury instructions as well is the judge said you don't have to render a verdict of not guilty just because there's reasonable doubt there. But if you have an overriding, abiding conviction of guilt, you don't have to render a verdict of not guilty. So I think that's also super important with respect to first degree murder versus manslaughter. I think it's going to be a lot easier to get that manslaughter conviction because of that jury instruction and just because of the lower threshold that comes with a manslaughter charge.
It's common, you know, for these prosecutors to request a lesser included offense. And sometimes the defense does it too. You know, not always, but it does happen. So it just all depends on how they believe the jury could view the evidence once it comes in. All right, guys, we're going to take a quick break. Keep the questions coming to us on Twitter, Facebook, YouTube, Instagram, Threads, and TikTok. I think I got them all there. I might have repeated one. We'll be right back. Stay with us. We'll take more of your questions. I'm Anjanette Levy, and you are watching Law and Crime.
Welcome back. I'm Anjanette Levy, and thanks for being with us here on Law and Crime. We are taking your questions in the YNW Melly double murder trial, so keep them coming to us on YouTube, Twitter, Facebook, Instagram, Threads, and TikTok, and we will get to as many of them as we can throughout this lunch hour. The state finished its closing argument. The defense will be up after lunch, and then after the defense, there will be a rebuttal argument we expect from the state. So let's get to our next question. Latasha Gaffney from YouTube. The prosecutor said Melly didn't want to leave any witness behind, so why didn't he kill Cortland Henry? Do you think the jury is going to ask the same question? Do you think they caught that part? So I will send that one over to you, Terry.
So I think what the prosecution is trying to say as far as that is concerned is Melly wanted the other two, Juvie and Sack Chaser, gone because he didn't want to split up the money with them, but he felt as though Henry had his back. That was one of the messages she read to the jury during her closing argument. So I'm assuming that her theory here is he left Henry alive because he was more of an asset than the others. Now, you know, if you believe her motive for these is, you know, the greed, the resentment, then she's saying that he did not have, Melly, the defendant, did not have any greed or resentment or any of those things as far as Henry was concerned. So that's why he allowed him to live, according to the prosecution.
Samantha GM from YouTube, Brian, if the state is sure with unreasonable doubt that Jamel did it, then why are they prosecuting Bortland for the same thing?
That is a great question, but I think the difference between the charges are that they believe, and it got a little weird during the closing argument as well when she was talking about principle and who may have actually pulled the trigger. They seem to backtrack from what I thought they were originally saying, that being that Bortland was merely an accomplice or conspired to or aided and abetted in one way, shape, or form, but YNW Melly is the shooter. They spent a lot of time saying that the shots had to have come from the back seat behind the driver, not from the driver's side. So when they kind of interjected that, well, you could kind of believe that both of them did the shooting, but they would still both be guilty. It seemed like she was playing her hand to say, I don't have a very strong argument for this, but here's an avenue where you can think of it either two different ways and still find that I'm correct. I think it showed that her case was a little bit weaker, but giving an alternative to still try to come out on top. If the defense can pounce upon that, I think they have a good opportunity and a good argument to point the finger at Bortland.
Afi, this one's from TikTok and it's for you. Couldn't the phone have been given back to Melly when Bortland met back with them at Fredo Bang's house? And this is from Che Joseph 23.
Hey, Joseph, great question. Could it have been given back to Melly? I think in the closing, from what I saw, the prosecutor is suggesting that someone went and got his phone that may have been at Pembroke, which was the location of the shooting, and that's when he got and the phone was returned to him. For me, I have been following the phone, I call it FTP, the whole time. And it looks like the phone was at the location of the shooting, and someone, or he, by he, I mean Melly, got it back, or someone brought it back to him, and he resumed his business as usual. That's what it looks like to me. I've just been following the phone and going with the phone data.
Our next question comes from Nick Knox, rather, 712 from Instagram. Terry, shouldn't the prosecution get more time than the defense in closing arguments since they have the burden of proof?
Well, the way our system works is they both get equal amounts of time. They do have that burden of proof, and because of that, they get an opportunity to do the rebuttal. They get that very last word. So that does give them a slight advantage. And I think what Christine Bradley did, and she did it well, is she laid out the case. She laid out her foundation for saying why she believes, one, that the shooting occurred inside that car, and why she believes, too, that Melly was the one in the back seat inside that car. She now gets a chance to hear what the defense has to say, and then she will get the last word. So she does get an advantage. The prosecution is given that advantage, and the advantage is the last word.
Threads question for you, Brian Buckmeyer. Southpaw Mech asks, after today, how much time will the jury have to decide the verdict in YNW Melly's case?
So thank you for the question. They would have all the time they want. No judge or prosecutor or defense attorney is going to rush them to get to that decision. Right now, I would say, as Terry Austin said earlier, they can even go into the weekend on Saturday. I would imagine they would have a week or probably 2 weeks at the very least until someone starts asking questions of, is this potentially a hung jury? Because it is a death penalty case, they're going to give them all the time in the world because if you do rush a jury or you do have any kind of influence on how or when they make the decision, that is an appellate issue, and you don't want that in a death penalty case.
Offie at Sundance JR from Twitter asks, why did YNW Melly send a drop pin to a friend to be picked up if the lone defense witness claims he was at home? Guilty.
So that's a good question. So then now we have to believe, was it Melly using what we now believe is his phone, that 9807 number, or was it someone else? Because remember, nobody on the defense side has admitted that he was using the phone and that he dropped that pin. That's just an argument that we've received from the prosecution. And it's also a very logical argument. Excuse me. It's a very logical argument. And again, the prosecution has done everything to point to the fact that that was his phone. He was using it. It was in constant use. We've got thousands of pictures and videos of Melly on that phone. So I think that, it's a great argument and a great position to believe that he dropped that pen and that it was him.
Terry Haley Perry from Facebook asks, why didn't they have Melly do a lie detector test or something of that sort?
That's an excellent question. Why didn't they also test him for, gun residue? They didn't do a lot as far as that's concerned. I'm not sure why they didn't do a lie detector test. That's something that's not usually admitted into court because it's not reliable, and they would prefer to, have reliable, credible witnesses on the stand or circumstantial evidence if they have it. And so the prosecution has used all of the circumstantial evidence that they have. They've done that cell phone tower, they've done the gun expert, they've done the DNA, they've done all of that. And that's how they're trying to prove their case, not with some lie detector, which, most courts have ruled don't have the reliability to be introduced into evidence because you can just be nervous and it could seem as though you were lying. So I'm assuming that's why they didn't bother to do a lie detector test for anybody, frankly. But they should have done some gun residue and some other testing and clothing gathering and all the things that the defense is saying the investigation did not follow through with.
Yeah, the polygraphs are inadmissible in court, but cops use them as like an investigative tool to try to detect deception, and you have to consent to it. I'm sure Melly didn't give a statement. He's not going to submit to a polygraph. Jeremy Lopez from YouTube, Brian, what verdict do you think will be the most likely outcome, and why would you say the prosecution proved without a reasonable doubt that Melly is guilty?
So that's difficult, not seeing all of the summations, because if you would ask me this question before the prosecution did their closing, I would have leaned more to the defense. But now it seems that I think someone said it earlier, they've really put together all the breadcrumbs really well. But as a defense attorney, I think of reasonable doubt as a whole. The prosecution, the better they are, the tighter and smaller that hole becomes. However, I don't think that hole is completely gone. I do think the defense has the ability to poke some holes. And I'll give some examples. The reason why I say that is the prosecution did a really good job of logical statement, and then made a leap and said, well, this is what that means. And that was their entire summation. Now, if you want to make the leap with them, for example, he's a blood, and we show him talking about being a blood, and he's a part of the gang. And when he kills him, he now gets more venues and he gets more notoriety, and that's why he did it. Well, that seems like a very large leap to believe that's why he killed them. But the rest of that is logical. If the defense can open up that reasonable doubt, I think they'll do a very good job. But don't forget, the prosecution gets the last word. So I think right now it's anyone's game or anyone's case. Sorry, it's not a game, it's a serious trial.
Afi, Jed Casey 8 from Instagram asks, is the jury allowed to ask questions when deliberating, such as, why did the car stop and Melly get in? What was the reason for this? Or do they just have to make their own assumptions based on the evidence provided?
Oh, great question. I really enjoy jury deliberations because you can tell a lot about what they're deciding between whether it's guilty or not guilty, or whether in this case it's going to be between the first degree murder charge and the manslaughter charge. You're not allowed to ask any side to elaborate and to fill in the holes, the prosecution and the defense. That's their job before the jury gets their charges and before they start deliberations. But you can't ask, hey, the prosecution is required to prove this element of the crime. What does this element mean? Explain this or that to me with respect to the law, right? So explain to me what first degree murder means. Explain to me what this element means in manslaughter. And when a jury asks those questions, usually each side can determine where their jury is leading.
All right, guys, we're going to take a quick break. Keep the questions coming in on all of our social media platforms. I'm Anjanette Levy. You're watching Law and Crime. Stay with us. We'll be right back.
Well, it's looking kind of bad for old Geico Lizard, man. Christine been dropping them. She been putting them pieces together. She had been dropping them pieces all over this trial in the past few weeks, and it was looking crazy. It was like she was you know what I mean? It was like she was all over the place, and we didn't understand. But it was like she was just like coloring outside the lines. But little did we know, Christine was Picasso. Christine was an abstract painter, and she is painting brilliant strokes today in the courtroom with all the evidence, and it's just coming together. It's just coming together. It's the pictures just being clearer and clearer. I'm pretty sure the jurors have a clear view of the picture that Christine is trying to paint. I'm sure that the jurors are looking at Christine and the case that she built and saying, yeah, I could see how he could do that. Yeah, I could see him in the back seat of that car. Yeah, I could see him murdering his two best friends. Christina on that motherfucker singing, I got murder on my mind. I got murder on my mind. Cook, Christine, cook. Cook, Christine, cook. Baby, listen. Let me tell y'all something. My God sits up high, but he looks down low. Let this be a lesson to anyone who think it is no God, who think that you could just do this type of stuff and put this type of negative energy out into the universe and it don't be no repercussions. Let this be a lesson to everybody who think that their transgressions, if they don't repent, if they don't go up under that water and come out a new person, if you think that those things go unchecked, let this be a lesson to y'all. God forgives, man. God forgives, he do. But you got to first seek forgiveness. You got to first ask forgiveness. Then you got to repent. For those people out here who just keep continuing doing these bad acts and think that won't nothing happen to them and they could continue to do these type of things, let this be a lesson to you. And yeah, I know it. I know that The judge ain't said what the verdict is and this and that, but I already know what the verdict is. Cause my God controls everything in this universe, from the little tiny ant to the great wind that blow across the mountains and shape the motherfucking plains. I'm just trying to explain to y'all, man. I'm not judging nobody. I'm not better than nobody, but ain't nobody better than me neither. My mama told me that. I'm just trying to tell you something before you go down this path of self-destruction. I've been here. I ain't do nothing what he did, but I've been in that on that path.
Welcome back to the Lunch Show here on Law and Crime. I'm Anjanette Levy. We are taking your questions in the YNW Melly double murder trial right after the prosecution's closing argument. We are in a lunch break in the YNW Melly double murder trial, and when the lunch break ends, the jury will hear the closing argument from the defense. So keep your questions coming in. They're great ones as always, and we're going to answer as many of them as we can. Terry Austin, this one is for you. Janina43 from Instagram asks, either Davis or Glass were lying on the stand. Can one of them be charged with perjury?
Ooh, I like your question. Yes, I think one of them could be. And it's interesting because those are the two people who were in the red Mitsubishi, and they both testified. They were the only civilians who actually were witnesses as far as this is concerned, and they had opposing testimony. We heard Trevion Glass talk about all four of the individuals who were in the red Mitsubishi came and left, and no one got in that car. And so it conflicts with what we heard Adrian Davis say. He also was in the red Mitsubishi, and what he said was the cars pulled over and Melly got into the red Mitsubishi. So what that jury is going to have to do is to determine who's telling the truth, and if the court wants to, they could charge one or the other with perjury. I think it'd be very difficult though, because I don't know how the court would establish that either one of them was lying. They're both giving their recollection as to what's happening, and while they are, contradictory statements, I think it would be difficult to charge them with perjury at this point in time in any event.
Brian, this next question's for you. It's from Breezy West from YouTube. Why would Bortland sit inside the vehicle and let Melly shoot inside the vehicle while they were staging the drive-by?
Good question. Unfortunately, I'm not his attorney, nor do I know what he was thinking, but I'm guessing it was a surprise to him that he didn't see it coming. Which, again, I think this came up earlier, lends itself to why not kill Bortland too? If you're surprising and shooting these other two people, did you have like a long conversation with Bortland where he like swore never to rat you out or whatever it may be? Why he did what he did at that time, or why he said it was a drive-by shooting, I have no clue. But it's another thing that the prosecution can't prove. And if it's a burning question and goes to the heart of a charge, it could be an issue for the prosecution's case.
This makes me think about the damage to the Jeep, Brian, that front end damage. It's like, did it happen while the car was moving? I mean, that kind of leads you to believe possibly it did.
Yeah, maybe that makes a lot of sense, Anjanette. Maybe the shots went off, and like I'm assuming like anyone else driving a car, you hear gunshots behind you, especially at that loud because it's inside the car, not out. You're gonna swerve. You're gonna go off the road. It makes sense that he could have crashed, turned around, and then saw two of the four people in the car bleeding to death.
Yeah. All right. Let's get to our next question. At @thebull_21 from Twitter. If the cell phone shows that the car stopped Offie on Pembroke Road and US 27, why isn't there any surveillance from the fire training center or the waste management recycling facility?
I think it goes to the investigation. So, and it also goes to the fact that there may have been no surveillance in that particular area. When they requested their surveillance, it could have been at a point when those two entities erased the tape or they recycled the tape. Who knows? I'm assuming there was an absence of that evidence for the reason that it never existed, or it was discarded somehow, or it was never requested.
Let's get to this next question. Rhyme for Reason, sorry, from YouTube. Who did the third phone found in the Jeep belong to, Terry? Why didn't the detective investigate that phone?
Well, apparently that was a prepaid phone. So we had Anthony Williams's phone, we had Christopher Thomas's phone, and this one was a prepaid phone. I think they attributed that prepaid phone to Henry, if I'm not mistaken.
Yes.
And there, yeah, exactly. And so my understanding is there wasn't much on that phone, and it wasn't anything that they were looking to find out from that phone. It was left in the car, and they ended up retrieving all three of those phones. If you recall the testimony, they said that the information on all three phones actually was destroyed, and so two of them, I guess, burned up, and the other one, the information just was no longer available. So they had those phones, but it didn't really provide them with any data inside the phone. They only knew about locations. They don't have any information as to what was in those phones in terms of messages, etc.
And the one they attributed to Cortland Henry was, it was a minutes phone where you buy minutes, and it appeared to be out of minutes. Let's get to another question. Iona Quinn from YouTube. Brian, do you guys feel the state has given enough evidence for the jury? Seems like she's only basing he's guilty by the phone being in the car. We all leave our phones somewhere.
I don't think at this point that, let me backtrack on this. It's a circumstantial evidence case. So I don't think we're ever going to get that direct evidence that says, here he is, he did it, gun in hand, we've got it. They don't even have a gun. They can't do that. But what I think that prosecutor Bradley did do was shut off enough reasonable angles that this could have occurred. So the cell phones traveling together, reasonable to suggest that he's with them. They didn't verge off in different directions. He stopped at the location. She said, well, I believe that's when they started clearing up the crime scene and picking up the shell casings. She gave us enough to say, hey, most of these arguments that the defense are going to make aren't reasonable. The question is, can the defense come back and either elevate those and say, she's making a logical leap here, guys. She can't actually know this. That's just her impression. And you can't convict based on impression. Or they can raise other reasonable doubts through other parts of testimony and say, this is why you should not find him guilty. I think there's still a little bit of reasonable doubt on the table, but prosecution always gets the last word. Maybe they can wipe that away.
Prosecution does get the last word, and the defense will have its turn after the lunch break, which ends in about 35 minutes here. And I know we're all looking forward to hearing what they have to say and where they go with this, other than, they didn't prove their case, which they said in their opening statement as well, that they can't prove the case beyond a reasonable doubt. Guys, stay with us. We're going to take more of your questions after the break. Keep them coming in on YouTube, Twitter, Facebook, Instagram, TikTok, and Threads, and we'll get to as many of them as we can. Stay with us. We'll be right back.
There's something really nostalgic about plants. My name is Eliza Blank, and I am the founder and CEO of The Sill. Plants have always been a part of my family.
Welcome to Law and Crime. I'm Anjanette Levy, and thanks for being with us on the lunch hour here on Law and Crime as we take your questions in the YNW Melly double murder case. We've heard the state's closing argument. It ended before the lunch hour, and court will resume at 1:30 in just a short time, and then it will be the defense's turn. YNW Melly, of course, is accused of 2 counts of first-degree murder in the October 26, 2018 deaths of his 2 friends, his lifelong friends, Chris Thomas Jr. and Anthony Sackchaser Williams. He faces the possibility of the death penalty if convicted. And, he has a co-defendant in this case too. His name is Cortland Henry, and he will be tried later this year in October, and he is not facing the possibility of the death penalty. So let's get right to your questions. We have so many good ones coming in. Did Melly have any prior convictions, Brian Buckmeyer? If not, is that taken into consideration when sentencing?
I think the answer is no. And please, Terry and Anjanette, correct me if I'm wrong. I don't think he has any prior convictions. If he did, it might come into, if he gets convicted and he goes to sentencing, I don't think a prior conviction would affect anything because he's either going to get death or life in prison. If this was, for example, a violent felony where he wasn't looking at the death penalty but was looking at a range of, say, like 15 to 40 years, and he had a prior violent conviction or even just a prior conviction, his sentencing guideline will then shift and be a little bit higher. But because we're talking about death or life in prison, I don't believe that a prior conviction would really have an effect here because the sentences are already so high.
All right, and that really wouldn't come into play. That might come into play if we get to the sentencing phase. Obviously, the prosecution would bring that up. So that would be something that would come in then, or even if he's convicted of the manslaughter, it would come up then. They're not going to talk about that in the case in chief. Dee from YouTube, the prosecution hinted, Offie, at a weapon possibly being inside of the satchel. So is it possible that Juvie is a possible shooter as well? Were his hands tested for gunshot residue?
Yeah, there's a possibility that he was a shooter, but I do think the way that the accident reconstruction experts set it such that the person who was in the rear driver's seat was the only person who could have shot Anthony and Juvie. It was one, and it was also just one shooter. I do believe he was tested for gunshot residue, and he was positive for gunshot residue, but we also know that there are many ways that GSR can transfer. If you've been in contact with someone who has gunshot residue, it's easily transferred. If you're anywhere around gunshot residue, it's easily transferred and it's easily washed off. But I do believe the prosecution has set it up such that there was only one shooter, and it could have only been someone who was in the rear passenger seat.
Mm-hmm.
Rear.
Yeah, you can just be standing. Yeah, you can stand next to somebody or in the vicinity, as you mentioned, of somebody firing a gun, and you're going to have gunshot residue on you. Jed Casey 8 from Instagram, Terry, what will happen if it's a hung jury? Will Melly go back to jail until a retrial, or could the prosecution choose to either drop the charges or offer a deal, etc.?
Well, it all depends. It's going to be up to the judge. If he is a mistrial in this case, then he could very well go back to jail, or he could be freed. The judge is going to have to make that determination based on what the parties are asking for. A mistrial doesn't mean he's guilty, and it doesn't mean he's innocent. It just means that the jury could not come to a unanimous decision, and the whole situation changes at that point. And the defense or the prosecution could say, look, I think that at this point in time, he should be freed. The judge can say, let me hear from both sides. The prosecution can say, no, I think the original conditions remain. And the fact that, they think that he may be a threat, they will argue that. And then the judge will decide whether or not, he can walk out at that point in time. Now, I will say the prosecution will have to determine whether or not they're going to bring charges again. So if they determine at some point that they are not going to bring charges, he will go free. So they will have to make that determination at some point in time.
All right, this question, Brian, from TikTok. YNW Melly's defense saying he types dat with a D, different from that with a THAT. Is that good evidence? And this comes from Melly Lover 1.
I think it's good evidence. Melly, what was the name of the person? Anyways.
Melly Lover One is the person asking the
That's
question.
what I thought. Well, Melly Lover won. I think it is a great argument. Anytime a defense can take what the prosecution is putting forward as a strong argument, that being, hey, after this, in a conversation with someone else, he texted, I did that, and tried to make it seem like the context of that conversation was him giving an admission, the closest thing they have to an actual putting a gun in his hand and him being the shooter. If the defense can find a way to sow doubt into that, I think it's massive, because now you have the prosecution going headlong forward saying, this is it. This is the confession. This is what you all should be looking at. But the way the defense paints it and says, look at the way he speaks. Look at other messages. It's clear this is not what this means. The prosecution has blinders on. It's a botched investigation, and they can go down the whole rabbit hole of the arguments they made during opening statements. I think it's a great argument. Whether or not the jury buys it, that's a different question.
I Dress and Rest from Twitter asks Afi, from what I understand, if Melly is convicted, he gets life or the death penalty, correct? I'm aware that Florida has no parole. I'm wondering if there are in-between charges that I might have missed. And so we kind of touched on this a little earlier.
So I think the in-between charge may mean is the lesser and for the defense of manslaughter. I'm not sure of what the minimum is for manslaughter in Florida. It's different by jurisdiction. By jurisdiction, I mean from state to state. So, but if he's convicted of manslaughter, then he will be sentenced, and then there may be an opportunity for parole for him. The only opportunity for the only chance where he would never see parole is if he gets sentenced for first-degree murder, and that's either death or life without the possibility of parole.
I just Googled while you were answering that, Afi, and it says that the maximum sentence for manslaughter in Florida is 15 years in prison and or a maximum fine of $10,000. So that's what Google told me about that. Okay, so our next question comes from, let's do this one. McGee_8789 from Instagram. Terry, so now that all the evidence is shown, the state still failed to put a weapon in Melly's hand. Will this play a huge factor in getting a good verdict?
Well, according to the prosecution, she thinks she has put a weapon in his hand, but not literally, because as we know, there is no gun in this case that has been located. So she believes that she's put the weapon in his hand because of the ballistics and the trajectory of the bullet. She's saying that it could have only come from the back seat on the passenger side, and she's saying that he got in the car and that's where he was sitting. So to your point here, I do believe that, you know, there is no gun, and if there was a gun, it would make it much easier for the prosecution. But she's making a leap, as Brian said earlier, that because of the positioning of the parties, that it was Melly who had that gun. I do think the jury is going to pause there. We've seen cases where there's been no weapon and you still have a conviction, and I think that is something the jury is going to be thinking about. Well, you know, I'm not totally 100% convinced, the jury might say, that there was a gun in Melly's hand, and you know, there's no gun residue. Whether they test it or not, there's nothing to really beyond a reasonable doubt say he was the one who did that shooting.
Melly Lover 2.0. I'm giving you all the Melly lovers, Brian, from TikTok. This is Melly Lover 2.0. I wonder if 3.0 is hanging out there somewhere. Why was Bortland let out when all the evidence is all to him, but Melly is sitting in jail and they have no evidence on him? So if Melly is found not guilty, can the state be sued?
I wish states can be sued for that. I'd be a very successful defense attorney, but unfortunately, no, you cannot do that. And to answer the first question, I believe the idea is that Melly, even though the prosecution kind of backtracked a little bit in their summation, Melly is the shooter based on the trajectory of the bullets, and that Bortland, YNW Bortland or Cortland Henry, he is not what we call the principal, not the one who's actually doing the shooting. He might have participated in some way, shape, or form, but he's not the actual gunman. So I think in that distinction, Henry was given house arrest because he was able to make the argument that he should not be within jail pending this case. And YNW Melly lost that argument because the evidence against him says that he is the shooter. I think that's the difference for the bail status or bond status.
Afi, this is from Instagram and the bowl_Rex. The prosecutor is saying Melly shot them and sent a pin to Fredo, but Fredo never picked him up. So where did Melly go when Bortland went to the hospital?
Well, we do know that a pin was sent to Fredo. We don't know for sure whether he picked him up or not. We've had limited testimony from people who were actually there immediately before, during, and after the murder. But from comments that I've read outside of the evidence that's been presented in court, he was picked up by Fredo and they returned to Fredo's house. But we saw in court, whereas according to the alibi witness, that Melly switched cars and was at home. And then later, everyone went to Fredo's house. So I'm not sure. I can't give you that answer.
All righty. Let's get to another question for Terry. This is from Blackberry from YouTube. Didn't Adrian Davis give a statement a year or two before stating the same thing he testified to? Didn't Travion say he was in the red car years ago, then changed after threatening jail time?
Well, we do know that Travion gave a prior statement because we heard the prosecution giving him information to refresh his recollection. So, based on that, he had a prior statement, but he couldn't remember a lot of what he said in that prior statement, and she had to refresh his memory about specifics in terms of timing and whether or not Melly came home or he came to Frito Bang's house. I don't remember hearing for Adrian Davis that he had a prior statement. He may have. If that's the case, I don't recall hearing him being asked about that statement and saying anything that's inconsistent. So if he did make the statement, he probably testified similar to what he said during that statement. And the real issue here is whether the jury is going to believe those two witnesses, because again, those two individuals were the ones who were there at the evening and they had opposing, statements essentially on that stand. One said that Melly got in the car, that was Adrian Davis, and the other said, nope, Melly stayed in the car where he was because everybody was in the same car where they started out at the studio. So we'll have to see what the jury thinks about those two opposing views.
All right. Well, Terry, we are going to let you go and grab a bite to eat before court resumes at 1:30. So thanks for being on and coming on with us. Brian and Afi and I will be back in just a minute. So stay with us as we take this quick break and we'll get to more of your questions. I'm Anjanette Levy and you're watching Law and Crime.
I'm going to drop the link. If you want to come up, hit the link. Good afternoon, Tamara, aka Peanut. Hey, Janelle.
Hey, what's up? How
Man,
you doing today?
Man, I ain't been asleep yet.
You sure about that?
I dozed off for a second. That's it. I'm talking about when I get off of work, I just went to sleep on the live. That's it. I ain't been asleep since.
Man,
I don't know how, and I gotta go back to work today. I don't know how I'm gonna make it.
I don't either. You can't. Well, put it this way: after they finish their closing statements or closing arguments or whatever, get off of here and go take you a nap before you gotta go to work.
Yeah, I might go work a little late.
Because if you haven't been to sleep yet, I know you're tired.
I just got when I was on live, I just relax for a second. Excuse me, what you think about the closing argument from Christine so far?
She did a good job. I'm not gonna lie. She finally connected some of those dots that she's been throwing out there the whole trial that didn't kind of make sense. So I'm not mad. Not mad at all.
It seemed like some of the stuff that she is talking about seemed like I kind of missed some of that stuff when the trial was going on. Like she talking about it. She put the
Yeah, but it was times that both of us fell asleep, so I'm not surprised.
Mhm.
And then there were days where I just really wasn't paying attention that tough because she was getting on my nerves.
Right.
Sometimes I would literally just turn the volume down and be in the chat because I didn't want to hear what she had to say. Her voice is annoying after a while.
It is.
And after weeks of watching this shit, it's only so much I can take. So,
Right. They were saying that excuse me, I was watching. They were saying that the defense not calling the expert witnesses to debunk what the expert witnesses that the prosecution had was very telling. They were saying that maybe they couldn't even find no expert witnesses to debunk the what the ballistics was saying, and all of this and all of that.
hmm oh, that's very telling because if you don't call somebody to, rebuttal what she's saying, all you have is to go off of what the prosecution said happened as far as the ballistics and everything else. So, yeah, I don't understand because I just knew they was going to have at least somebody to come in and, excuse me, debunk or try to debunk the ballistic testimony at the very least, and
Right.
doing the trajectory and the bullet trajectory and stuff like. I knew they were gonna have somebody come in and debunk that at the very least.
Me
So
too. Me too.
if they didn't do that, yeah, that's not looking good for the defense at all. And don't get me wrong, they don't have to put on a defense, but when you don't put on a defense, the only thing the jury has is to go off of is what the prosecution says.
Right.
So it's not looking very good with that at all. I was very shocked to see that, you know,
Right.
they didn't do that. But this case has been kind of crazy and from the word go. So
Right. What's up, Kenny? What's up, Invisible Woman? How y'all doing today?
Hey, how y'all doing today?
good. How are you?
I'm
Hey,
doing good. Feeling myself.
I know
How,
that's right.
how y'all feel
So
about
how y'all doing? How y'all doing?
all right.
The only thing that, Christine, I'm glad she got caught for lunch so she could stop because I don't think she know when to stop.
Mm-hmm.
But, that was good. That the judge ordered them hours. Not only
Yeah.
that, I thought about this when she was talking about the bullets because I was paying attention. And she said the bullet went into the door, so one of the doors was open. Why? I'm wondering why the other door went open because I know he went sitting in the car while he was shooting.
Mm-hmm.
Like,
Just
why didn't
closed the
no
door when he
bullets?
got out. That's all.
I know, but why didn't no bullets hit on his side?
Come on, Melly side.
No, the front seat.
Come on, Portland side.
Yes.
Oh, she explained that. She said that they found a projectile under the brake the gas pedal, the brake pedal. And she said that if he would have been sitting there, he would have got shot.
Mm-hmm.
She said that. Mm-hmm.
So that means both of them was out the car.
Yes,
Yeah.
ma'am.
Shooting after,
Yeah.
after the deadly shots. But the
Yes,
Oh
ma'am.
yeah.
projectiles were up under the brakes.
Yeah. Up under the braking gas pedal. I think it was the brake pedal
Hold on. Yeah, I
specifically.
heard her say that this morning.
Yeah, see, I ain't hear that.
Mm-hmm. When she was showing the car, she was showing like the roof of the car, and she had the arrows pointing, showing which way that the projectiles was going and stuff. Because she even said if Melly would have been sitting in the car, he would have got shot in the
Shot in
knee.
the leg.
Yeah.
Yeah. So the projectile. So when you
Oh, who
shoot
is
a
that with all this background noise? I'm sorry, I didn't mean to
That's
interrupt
Kenny.
you.
I had to mute him up.
Okay.
My bad,
Okay,
Rudy
so when
boy.
you shoot a gun and
You
the
good?
projectile, it goes back out of the gun, don't it?
Say it again.
So when you shoot a gun, the projectile goes back out of the gun, don't it?
What you mean?
That's the casing comes out
Okay,
like the side
okay,
of the gun.
Yeah,
okay. So it went through, but it just went up under the pedal of the brake.
that's what she said.
Oh, okay. See, I didn't know that.
If both of them would have been sitting in that car, both of them would have been shot. But
Mm-hmm.
from the path of the fake drive-by shooting bullets.
Yeah. Yeah, I think she did better. I mean, with time being on her side, you know.
I think when she had a chance to like talk and as like summarize everything, I think it kind of came together. She still kind of like was all over the place when she was doing the case, but I guess being that she was able to kind of freestyle and put it all together in the in a closing argument, it kind of looked you could see the picture better. That's what I'm thinking. You know what I mean?
Yeah, that's what I mean.
Well, she was just able to actually go sit down and write out what she wanted to say in a clear and concise way, instead of being all over the place like she was in the trial. So
Yeah,
I can
but
appreciate
she
that.
gave Melly a lot of props. She made it seem like he had pressure on him. She did all that, like she did that, but I was like, "You're doing too much," because she started
I
talking.
Go ahead.
Oh yeah, because she started. It was like she started defending like him.
I
I
think
don't
it
know.
was
It
more
kind of
so
threw me
trying
off.
to. I think it was more so trying to give motive than necessarily trying to defend him. Just giving the reasons why he would do this. Why would you kill your two best friends? That's been a question that has been asked multiple times in multiple ways during this trial. And I think she was just trying to explain, well, this is why, because ABC, you know what I mean?
In the
So,
gang stuff, now that's another thing. I wanted her to leave that out. Don't
yeah,
Right,
she could have left that alone. I
right.
really think she's just banking on this gang shit. And it's just like, lady,
Yeah, let
we
it go.
all know that ain't it. Let it go.
Mhm.
But she's pushing for this first degree murder with the gang ties. However, what is it? A gang for the furtherance of the gang, whatever, however it's worded. Um,
I still ain't buying that shit. I told you
no,
I wasn't buying that shit when I read that shit. I'm telling y'all before the trial started. Remember I say, boy, they reaching with this with him.
yeah, I mean, none of us have really who've been here and read all of the depositions and statements and everything before the trial started. None of us really thought it was
Yeah,
gang related.
yeah,
You
because
know,
messed up when she said, that would get him more shows. But
Stop for real.
with the
now she must have said
affiliation,
that in the very beginning because I didn't hear the very beginning of it. I
yeah,
was
she
on the
said
phone.
being affiliated with these guys could have got him more shows, so he could get more shows.
Um,
Okay.
I'm gonna tell you too. It was interesting to see that. First, it was interesting to know that other phone in that car, they said that was Bortman's phone, the prepaid for the phone that bought the minutes. Like we didn't hear it really that
No, we didn't hear that.
right. You know what I'm saying? And so I was like, oh, okay. So the fourth phone was Bortman's phone, according to her.
But first of all, the judge did, the defense did object twice to
Hmm.
something she was saying.
Mm-hmm.
And so the judge was like, note for the record, this is her argument.
Yeah, no, I did hear that.
Basically, she could make her own argument in whatever way she want, long as she don't bring in no evidence. Well, I don't know what she was doing, but for
Yeah, I did
because I
hear
never
those
heard that
two.
about that phone because we was wondering who phone was it.
Right.
Right. And somebody say Enroll say they added the manslaughter. That's very interesting. I'm gonna tell you, I'm gonna be honest with you. It's a good thing they did that. I'm gonna tell you, I think it was Casey Anthony or one of them. I've seen where they overcharge somebody in the jury, and they only have one particular John, whatever, what's the word I'm looking for? Level of
One.
murder,
Mm-hmm.
whatever the word I'm looking for, level of murder on there, and they can't, and once they don't, God damn it, they probably finna, boy, they gonna, man, fuck it. I know they're gonna get me with that video. They're gonna get me. They got me last time. I keep long crying. I gotta stop doing that shit. They when they play them videos, they demonetize your whole video. But anyway,
But when you do this type of stuff where you got us up on the panel, stop playing them in the background. You just watch it on your computer so you know when the trial come back on
yeah,
and you can put them back up
petition,
or
man,
whatever.
real.
So they don't keep hitting you with these strikes because it's unnecessary. Because we don't want to see their asses no way.
Yeah, they got
I
me.
think
They got
everybody kind of
me.
tired of them.
But yeah, so they put that on there so that if the jury do not feel like he got first degree murder, they can actually have lesser murder charges to find him guilty on. So it is a good thing that she
Yeah.
did that. You know what I'm saying? I mean, I know some people may want first degree murder, some people may want the death penalty, but at the end of the day, I'd rather get a conviction and
Yeah.
justice than for somebody to get off totally because they just didn't have another option of what murder they may have thought he did. You know what I'm saying?
Exactly.
Yeah, Tanel, you was right about that when you said that the other day. That death penalty thing was just, it was all cap.
Mm-hmm. Mm-hmm.
It's interesting today to see a lot of these law and crime experts or whatever. A lot of them saying that they feel like he's gonna lose this case. You noticed that this morning? I saw that this morning.
Yeah. Yeah, they switched over after the closing statements. I think that's hilarious.
Right. They switched up. I'm like, I'm listening to him. I'm like, nah. It seemed like y'all kind of just was like going that way because y'all see it was a lot of Melly fans on y'all network, and now that the case is over with and it's closing arguments, now y'all like, oh yeah, but yeah, he's cooked. But about 2 weeks ago, y'all was so all pro Melly.
Mm-hmm.
My thing about it is, I feel like like I said, they had to do it for their network because they take them polls every day, and they're not guilty. If you look at them, they
Well, that's because the only thing that's over there is Melly fans.
yeah, and so it's some people be over there be like fries. Turn on the fry, he done, but yeah,
Right.
it's mainly people over there that's saying not guilty. But
Mm-hmm.
my thing about it is, I'm just like, this whole case has been a show.
Right. I hear you, M. Rose. Go ahead. Because I was just saying something.
Yeah, I feel like it has been a show for the youth. If you don't know how to get away with murder, you know now.
What? Listen. Ooh, speak. Go ahead and speak.
I'm sorry to say it, but see how the internet in the world messing up for the kids.
Mm-hmm.
They just show us, man. That's what scared me. It ain't even this trial. It's the backlash from it. Whether he guilty or not, you done showed the whole world how now gang members finna start changing their whole
style up.
I thought about that last night. I tell you no lie. Lord, take the breath out of me. I thought about that last night. I say, damn. I say, boy, you sure know how to get away with murder now watching the Melly case, don't you? You know what I'm saying?
They ain't even showed this much with Young Thug. Like, I don't even know what's going on with him.
Yeah. Yeah, it's definitely a blueprint on how you can possibly get away with murder if you stage it right. Um, it's sad, but it's true.
Exactly. He was only 18 then, so imagine if a 24 or 25 or a 30-year-old watching this.
With a little bit of money.
Yeah.
Yeah.
But he was 19. He wasn't 18. He was 19.
19, yeah.
Yeah, he was about to turn 20 that year. A couple more months before after he got arrested.
Well, you know what I mean. Men don't hit their peak to 35, they say to Neil.
Girl.
That's when it really changed for him.
I've been saying that. You know, they want to get mad at me when I say 29 to 39, you still semi-grown, but it's the truth.
Nah, that's the truth. That's the truth. That's the truth. Definitely. I'm 42. Trust me, it's the truth.
You know, you don't get grown till you about 40. Completely grown.
Yeah.
Yeah.
Something hit you in your 40s and you be
Um,
looking at everything different for
Yeah.
real.
I
Like
be telling folks.
This is true.
I woke up one day and said, I need to change for real.
Oh, look at that look. Did I see the cocker spaniel lady coming up from over there on Melly and them people? We knew you was YNW Terry. I seen you. YNW Terry.
Is this grandmama in there?
Let me look. Hold on.
I know I seen his mama and his little brother.
All them light skinned people is in the back still.
They look
Probably
like
fans.
reporters and
No, on the very back row, those are fans. Look at how young that one is, right?
yeah.
Yeah, those are fans. I don't see his grandmother.
That might be her with the long hair.
It might be. Yeah, that's her. That's her. That's her right there that just came in. That's her.
That's the one with the YNW tattoo on him.
Mm-hmm. Yeah, that's her.
Mm-mm.
You know, and what kind of grandma getting young nigga world tattooed on them? You know,
Man.
that's what I'm saying. We mixing the grandmas nowadays. My grandma wouldn't have dared.
Happy birthday, Kamal. Happy birthday, G.
Oh, happy birthday, Kamal. But baby, please,
Ma'am,
when I
ma'am.
tell you, my grandma had a heart attack when I got my first tattoo, and I only got two.
Why they can't show the other side?
I mean, because they haven't showed them the whole trial, unless they were walking by the camera when court was going in and out of session.
Or it ain't nowhere to put no camera over there.
Shout out to Silk Foster Jr. Hey, look, I'm gonna say this too now. Let's just let's think now. We know this talking ass black dude. When he get up there and do his thing, we know he gonna make it look good now. That's one thing this nigga can do.
Yeah, the black man doing it.
I'm assuming he better not let Danny DeVito do
it. I didn't know the black man was doing it.
I don't know either. I'm just assuming because he's just the better talker of the two lawyers Melly guy. I'm just saying.
Is that the grandma?
The one, no. Is it?
That kind of look like.
I can't tell. I thought that was her just walked in with that black and white on over there, but I'm not sure.
Hey, y'all do me a favor. Y'all hit that like button, man. Please hit that like
No,
button.
that's her over there with the black and white on. She just turned her face enough for me to see. That's her right there. Yeah, hell yeah, that's her.
That B
I know what she looked like. That's her right there. That's Granny.
And that's B Slime right there.
Oh,
yeah, I know his bad walking ass.
Hit that like button, y'all. Please hit that like button.
He walked like he got bunions already.
Leave that baby alone.
He do. Shit. He walk like his feet hurt all the damn time.
He wobbling from side to side.
Yeah.
That's cool. They pants be too tight.
That's why I said I hate skinny damn jeans. Shit. I should not be able to see your nut print when you walking down the street. That's nasty.
Not only that, they got this thing where they don't want creases in their shoes.
Hey, B Slime.
Yeah, and they be walking all jacked up on purpose.
You
right.
Got bunions, y'all. At 17.
He sure walk like he got bunions. I promise you.
Hit that like
my
button,
auntie had bunions. She
like
walked
button.
just like that.
Oh, he looked like he about to have a heart attack.
Man, they gotta depend on his ass because I know he's shitty as a bull.
As soon as he take
I
them
know he is.
As soon as he take them dreads out, the motherfucker gonna fall on the ground. I'm telling you. That shit done pulled them motherfuckers off to the bike. Look at that.
Like I said earlier in the chat, they holding out about 3 strands of hair and some of them little voodoo prayers that he be doing.
Hit that like button, y'all. Please hit that like button. Hit that like button. Please hit that like button.
That motherfucker done developed trichotillomania while he been in prison because he just picking his hair out the top of his head like a motherfucker, nervous as hell. Look at that shit. Look at how, but seriously, look at the difference at the beginning of the trial and now, how far back his hair has gone.
Look at that frontal lobe. Look at that goddamn cerebral, what do you call it, cerebral cortex up there. That nigga,
Cerebral cortex.
that nigga got a big ass cerebral cortex.
Cerebral cortex, man.
Cerebral cortex.
Him and his
He got a
mama
big
look just
cerebral
like
cortex.
What'd you say, Adrian?
I said him and his mama got the same head though.
They
Is
do.
he talking?
He
Is
talking.
getting started?
All right.
Yep.
And the reason they said that.
Fuck wrong with his neck, y'all? Fuck wrong with his neck?
Stop it.
Either him being a principal or the one who caused the death of Williams and Thomas. It's that simple. Where is the fire? Was the message. They say.
Hey, y'all, I just want to say this, but they might be fucking up not letting that black dude talk, boy.
All right, Adrian.
All right, Adrian.
My interpretation, based upon the evidence, is where's the weed, the marijuana? That's the problem there, folks. They're interpreting it as opposed to calling these various people to tell you what they mean. They mentioned Frederick Gibbons, Frito Bennett, Mariah Hamilton, Peasy, Patrick Deloach, Dontavius Withers. They opened the door. We don't have a burden. As the court told you in jury selection, the burden of proof is on the state. And the court told you during jury selection that this is a first-degree murder case, wherein the penalties are either life without the possibility of parole or death. You folks are going to determine this young man's fate. And they come in here and give you alternatives. They come in here and give you their interpretation when we don't have to do a darn thing. And that principle was so important that His Honor read you that instruction at the beginning when you were going through the process. That he just read it to you before the state got up and gave their opening closing statement. He told you that this young man has pled not guilty. That means you have to presume him innocent. That means that that presumption stays with him until and if the state of Florida can prove their case beyond and to the exclusion of every reasonable doubt. The judge goes on to tell you, and it's in your packet of jury instructions, that the defendant, Melly, is not required to present any evidence or prove anything. So it's nice that they're interpreting these things, but the bottom line is they don't even know. Because they've given you just two alternatives. Either he's the shooter or the principal. Make up your mind. Tell these folks what it is. Now, how do you go about doing this? Well, the judge gave you an instruction on that. You're to look at the evidence that's been presented to you. Remember, we don't have to do a thing. All we have to do is show up and behave. Now, I don't know if I've behaved totally correct during the course of this trial. So, on behalf of us, let me apologize if I have or we have offended any of you. And I would ask you, I would plead with you, if I or any of the other individuals have done anything to irritate you, don't take it out on this young man. Still hold the burden of proof to this table. Now, why do they have the burden of proof? Because they are the state. They are the government. As we learned in this case, They have the police department of Miramar. They have the Broward Sheriff's Office. They have the DNA labs. They have experts, the FBI. They have everything at their disposal. And that's why our system of justice is different than anyone else in the world. We recognized a long time ago that when the government accuses somebody of a crime, they have the money, the resources, and the person power to attempt to prove to you all that a person has committed a crime beyond and to the exclusion of every reasonable doubt. Now, how do you go about doing it? And before I get into that, first of all, let me also thank you, because we have interrupted your lives for it seems like months. And we have put a horrible burden on your personal lives, your family life, and whatever. And all of us applaud and thank you for your service. You folks have gone way beyond the call of duty. And I think we all recognize that. But how do we go about determining, and I shouldn't say how do you folks go about determining if the state of Florida has proved their case beyond and to the exclusion of every reasonable doubt? Well, the judge just gave you that instruction. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. Remember, we just got to show up. And how does a reasonable doubt occur? Well, the judge told you. It can come from the evidence itself, a conflict in the evidence, or a lack of evidence. You don't need all three of these areas. But I suggest to you folks that we have a reasonable doubt from the evidence that has been presented, that there is a conflict in the evidence, and there's a lack of evidence. This is an unusual case, kind of like the medical examiners. The two medical examiners said it's unusual because normally you can't tell what shot occurred first, second, or third. And the chief medical examiner came in here, Dr. McDougall, I think, and told you it's only happened to her in her entire career, I think 2 or 3 times, that she could tell you which shot occurred first in this case. So knowing that, let's look at what the state presented. But before we do that, we can agree upon a couple of things that are not in dispute. They said that Melly is a talented music artist. We agree with that. At the age of 19, based upon the evidence, he was making more money than probably everybody in this courtroom, including us. Number 2. Oh, I'm sorry. I thought you were okay. Usually, judge stop me immediately. Number 2 is that Cortland Henry changed his clothes before he went to the hospital. That's what they said just 10 minutes ago. Number 3, that there's absolutely no eyewitness that will implicate this young man to this crime, these crimes. Number 4, they talk about premeditation. I suggest to you there is absolutely no evidence whatsoever to show premeditation. And the last one that we absolutely agree with, and they admit it, the Miramar Police Department lacks the training. Those aren't my words. That was Miss Bradley just an hour ago saying, not only did Miss Bradley say that, but Sergeant Williams also said they lacked the training in one of the worst investigations. That's why I pushed aside their reports. Now, the state produced over 100 exhibits sitting right here on the floor. Ms. Bradley made reference to some of them. They're all here. And I put them on this side of the podium because I suggest to you that this is a smoke screen. I suggest to you that this is open for anybody to interpret any way they want. When I say something sarcastic, you don't know if I'm serious or not. I can tell my colleague, I hate your guts, and it could be joking, and I am joking. And that's what this case is, and that's all this evidence is open for interpretation. That's not evidence proof beyond a reasonable doubt. Now I put on this side of the table really the evidence that means something. There's one other exhibit, but it's on a little USB internet thing. And that is the video leaving the studio, showing the 2 cars and the 8 individuals that left. Sitting on this side of the table is the broken cell phone that Moretti could not tell you whose it was, and the 9807 phone that Melly uses, as other people do too. These are the 2 key pieces of evidence. These are what I suggest you focus in on, because you can take any one of these items, any one of these text messages, any one of these pinging on maps, and you still don't know what was said, what was meant, and more importantly, who said it. I leave my phone, and I'm sure you all, in the house, and my wife picks it up and sends a message. And it looks like it's coming from me. And sometimes she sends messages that I'm kind of shocked about. But you don't know. So let's put the 100+ exhibits to the side for a moment. The state called 26 witnesses. I think I counted. And I suggest to you that you should look at 11 witnesses very carefully. And why do I say that? Because when you look at these 11 witnesses, you will find out that there's a conflict in the testimony, that there is a lack of testimony, and the third way is from the testimony itself. The first one that I would like to talk about well, before I talk about the first witness, I want you to remember one thing. On October 26th, that day of the shooting, we learned immediately that that Jeep was taken to a secure area. And it was searched for over 15 hours by 2 crime scene technicians. And you heard how they pulled out the evidence, some foam, some projectiles, I think a can, everything, and photographed the vehicle. Now, why is that important? Because that vehicle was searched. You know that? Want to take a break? That vehicle was searched again months later. But it didn't stop there. Because about 3 years later, miraculously, even though it was searched for hours by crime scene technicians, Sergeant Williams comes into the scene at the request of the state of Florida, this particular prosecutor right here. And miraculously, he finds additional evidence, 2 projectiles and a bloodstain that obviously everyone else missed. That should tell you something about the quality of this investigation. That should give you a clue as to what's going on in this case. What happened was, once they got the surveillance tape of the individuals leaving the studio, they knew that Cortland Henry, Williams, Thomas, and this young man got into the Jeep. It's shown on the video. In the Mitsubishi were Adrian Davis, Patrick Deloach, Trevon Glass, and I'm missing one other. Withers, Dontavius Withers. And we know that on October 26th, when Moretti saw that surveillance, Cortland Henry identified all of them. And in fact told them that he lives at this young man's house. I made a mistake. Jacoby Mills was in the car. It was Jacoby Mills, Adrian Davis, Trevon Glass, and Dontavius Withers. Okay? I can't keep the names straight. I'm lucky if I can remember my own name. That's why I haven't written it down. We know that Moretti identified all 8 people that left the studio on October 26th. We also know that Moretti knew where this young man lived, along with all the other 7 people that left the studio. We all know that, according to the state, Cortland Henry lied to the police. And we also know, as the investigation progressed, that Cortland Henry had blood matching the victim on his clothes. And he also had GSR, or gunshot residue, on his clothes. If that were true, when you saw the pictures of the Jeep, all bloody, blood all over the place, and we learned that you could spray and determine if there was blood right here on the carpet, even though you don't see it, why in the heck don't you get a search warrant for the house? Why in the heck don't you? Don't tell us we didn't know where he lived. Don't tell us it was months later, because they go into the car 4 years later and do this. So why don't you do it? Because Detective Melly and the Miramar Police Department, as everyone has said, lacks the experience and the training. We don't have to do a darn thing, folks. We don't have to do a thing. But let's go into the 11 witnesses now. The first one, and they mentioned it, George Bello, the manager, the head guy of the gun and tool mark unit of the entire Broward Sheriff's Office. And he tells you, after we get a great education of guns and projectiles and casings, We have to bring out the fact that can you tell or determine the distance between the shooter and the victim? Can you tell us that with all your experience? What does he say? I can't do it unless I have the weapon, unless I have the ammunition, because ammunition, the weight of ammunition could change the distance. And you have to have the weapon in order to do that. He cannot even tell us if it was one gun, two guns, or more. He's honest. He tells you that without the weapon used, I cannot place the shooter to the victim, or victims in this case. Now, why is that important? Because a reasonable doubt can arise from a conflict in the testimony. If you believe George Bello, and I suggest you should, then he totally contradicts all the testimony of Sergeant Williams, who comes in here 4 and 5 years later and says, I can tell you where shooter one was, and I can tell you who the shooter is. You talk about a conflict in the testimony? It's one or the other. It can't be both. And he tells you, in addition to that, that the environment has to be considered. Now, Williams tells you he goes out to the scene some 4 or 5 years later and has no idea, nor did he even check the terrain, the environment on that particular morning out. So you got to believe one or the other. You can't believe both of them because they are in direct conflict with each other. But let's go further. The next witness that you should consider is FBI agent Brendan Collins. He is an expert in tracking phones. He is not only an expert in Broward County, but he's an expert, and his team have been specially trained to map phones, not only in this country, but anywhere in the world if he's called upon. They brought him in. And what does he tell you? This expert. I cannot determine precisely the location of a phone. I cannot say 100% the phone is in, and you saw the band, it looks like a banana. He says, I think it's somewhere within this area, but I can't be 100% sure. He's candid with you. And he further tells you that the call detail records are limited. And I can't tell you who had the phone at any particular time. And most importantly, he tells you in making the mapping of the phones, the FBI, the special agents, do not use 2 items that are on the bill. That is the environment section, and he does not map out based upon the longitude and latitude. He goes to the cell towers and where they're bouncing off. And it could vary depending upon the strongest signal or how busy that network is. Well, he contradicts Williams, the one who comes up and tells you the phone is at this location here, this location here, this location here, at these particular times. It's one or the other, folks. I suggest to you there's another conflict in the testimony. The next witness I think you need to pay particular attention to and really get a flavor of what this case is all about is Felicia Holmes. Felicia Holmes tells you that the Miramar detectives, Moretti and his group, threatened her, bullied her daughter, told potential witnesses they were going to prison, told witnesses that they may never see their children again, told a witness that he was going to be deported, even though he's been in this country since 5 years old. He was going to be deported to Haiti where they won't feed you. The place is, with all due respect, and excuse my language, but it was his language that he used, shit. This is the great detective. This is why this kid's sitting here. They have intimidated and threatened everybody. So I ask you, I beg you, to consider Felicia Holmes, because that tells you what's going on. When Moretti got that surveillance tape and realized this young man, this little kid, excuse me for calling him a kid, he was 19 at the time, was a rap star, making more money than he'll ever see in his entire career at 19. He got tunnel vision. And he wanted to nail this kid. And what better way to move up the ranks, get some publicity, is to arrest the star. If they arrest Howard or myself, they go, who the hell is Addleston? Who the hell is Howard? That's the bottom line. So he just focused in, and everything was directed to get this kid. That's why he ignored everything. And that's why he intimidated and threatened anybody that said something different. So I ask you to pay attention to Felicia Holmes, because you do get an idea of what this investigation is. The fourth witness was a Kurt Rhodes, the DNA expert. Now, why is he important? Because while we were picking a jury in April and we were off in May, this prosecutor asked him to go back to the car and check some DNA. Now, why would you do that? The case, according to Moretti, is closed as soon as this young man is arrested. Why do you go back 5 years and ask an expert, a DNA expert, to do some more testing? This kid walked into the Broward, voluntarily surrendered. And 5 years later, they have the audacity to say, do a little more testing. Why? Because now we're in trial. And they realize there's problems. Why else would you do it? Three years after this young man surrenders, they bring in Danny Polo. I called him the masked man. He came in here for a few hours, if you recall, got on this witness stand and wore a ski mask over his entire face where you could only see his eyes. They came in here. He got involved in 2022 at the request, again, of the state, the prosecutor. What was the purpose of that? The great gang expert? They wanted to link him to some gang. You know, in the rap culture, whether you want to accept it or not. Gangs are attracted to it. If you want to be successful in rap music, you are going to pick up some of the nuances of various gangs. Snoop Dogg, to this day, it was.
No problem. Yeah, ladies and gentlemen, this argument, all right? Proceed, counsel. Discussion goes over.
Snoop Dogg, to this day, does hand signs of a gang. And he does that because he realizes it promotes his music. That's the bottom line. And because he wants to promote his music, make money, he's all of a sudden this big gang guy. And they wait till 2022 to bring him in. Thought the case was closed, according to Melly. And they show you some text messages from, I think it was Gino Burke and Wando, who fought with Anthony Williams previously. Now, certainly, if the investigation is being fair and you want to find who was involved in this case, you would relay that information to the lead detective of people of interest or suspects. And what do we find out? Moretti has no idea who Gino is, no idea who Herc is, and doesn't know about Wando. This is a great investigation. But he also refers to some text messages where those individuals that are in fact associated with the gang text him and he's not responding. And to the point of not responding, they say they're going to put you on the plate. Now that's not for dinner. That's not for breakfast. We learned what that means. If you don't start responding to us, we're going to have you killed. What the heck's going on? Why wouldn't you investigate this? They want you to believe that there's no evidence of that. How do they know there's no evidence if they don't investigate? They don't search. They don't look. You got all these phones. Get Gino and Herc. You have their text messages. Go get their phones, track them, and see. We don't have to do a thing, folks. The presumption of innocence stays with us during the entire trial until and if they can prove beyond every reasonable doubt that this young man did anything wrong. Moretti didn't want to look at that. Why? Because God forbid they find some evidence. His arrest of a star is down the tubes. That's the bottom line. I want you to pay particular attention to Dr. McDougall and Dr. Saunders. Because those two doctors, one being the chief medical examiner of Broward County, the other one, an associate medical examiner, I think now employed in West Palm Beach, say to you that the first shot to Williams and Thomas were fatal, deadly. Why is that important? Because according to Sergeant Williams, Thomas's injury to his hand came first. It was a defensive wound. We know that couldn't happen based upon the medical testimony. So you either have to disregard the medical examiner and accept what Williams' testimony is, or I suggest, now that you have four experts, contradicting Williams' testimony. And that is Bello, Special Agent, FBI Agent Collins, and two medical examiners. Conflict with Williams' testimony, that you should take Williams' testimony and ignore it, toss it out. You can't have it both ways. It just doesn't work. And then we get to really their star witness, two star witnesses. Sergeant Williams. I think I've talked a bit about him. And I think the most amazing part of his testimony is that he does not get involved in this case until 3 years after the incident. Again, at the request of the state. Again, because they realize they have problems. And I applaud them to recognize they have problems. And miraculously, as I told you earlier, even though the Jeep was searched for hours and hours, processed for hours and hours, he finds additional evidence. 2 projectiles that everyone else met missed, and a blood stain that is important. And that when he did his analysis, 2 important things occurred. He didn't go in there blindly to do any analysis. He told you that the prosecutors in this case told them that the defendant in this case was this young man. And we need you to do a trajectory analysis to put him on the scene. Now, I suggest to you, you could have a Jolly Green Giant and a midget. And if you give them the dimensions, the height and his arm length, with this mathematical formula, you could say the Jolly Green Giant or the midget was a shooter in this case. They would either be closer to the car or further from the car, depending upon their size. If you want to do an analysis, if you want to do an investigation, if you want to figure out who the shooter is, why do you point to this kid and tell him, this is what we want? Why do you do that? This is the great investigation. This is what they want you to do in order to render a verdict that could take him. And tell him that he's going to live life in the state penitentiary without parole or being on death row. This is the investigation they want you to rely upon and say it's proof beyond and to the exclusion of every reasonable doubt? I guess so, according to them. And they call Danny Benitez. Who the heck is he? He was on the stand for all of about 2 minutes. Danny Benitez gave Detective Moretti the surveillance tape from the Montessori school. You watched it. It showed, I suggest, nothing probative to implicate this young man in it. But we learned, not from him, but from Moretti, that he doesn't go to the drugstore on Miramar Parkway to check their surveillance tape. He doesn't go to Applebee's to check their surveillance tape. He doesn't go to Polo Tropical or the gas station or the bank on Miramar Parkway to check their surveillance tapes. When the car's on 184th Avenue, he doesn't go to the fire station to check their tapes, surveillance tapes. Doesn't go back to the two elementary schools, Sunset Lakes and West Broward Elementary, to check their surveillance tape because he knows it all. He knows it. How do you know it if you don't check it? How do you know something unless you investigate? We don't have to do a thing, folks. We don't have to do anything except show up. And begrudgingly, we did. Where the Montessori school was, on Pines, there was a tractor supply company and another school. Why don't you get that? And come in here and say, you know what, folks? We checked all of this. Instead, what they do is take a helicopter ride 4 or 5 years later. And we have to sit here and watch as they fly the route. And we have to watch how they drive the route. Not checking what the traffic conditions were that day, back 4 or 5 years ago. Not checking what the weather was 5 years ago in October 26th. What's the purpose of that? Just to add more of what I suggest is a smoke screen. You look at all this and say, heck, 100 exhibits, 500 photographs out of a cell phone, all these text messages. What does it mean? Hopefully, for the state, you'll say, hey, where there's smoke, there must be fire. And say, hey, too bad, young man, too bad. There's a lot of stuff sitting here. And hopefully you will not fall into that trap. And then we get to the lead detective. Well, before we get to the lead detective, I think I missed something. Trevion Glass, the individual who got into the red Mitsubishi, the man who is convicted of 2 felonies. Now, why is that important? Because the judge read you an instruction on some of the factors to look at in determining whether or not to believe a witness or not. And he told you that one of the factors to look at is whether or not the witness has been convicted of a crime. Trevion Glass, the state calls, as their star witness, basically, to say Melly never got into that red Mitsubishi. And he told you one interesting thing. He said he's got a case pending right now, and he doesn't want to go back to jail. Now, who has the authority to put him in jail? We don't. There's only one person who can put him back in jail. And that's the state of Florida, whether it be through the state attorney's office or the police department. And he miraculously is the only witness that says no one got into the red Mitsubishi from the recording studio. But he tells you, doesn't tell you how he gets into Melly's house. Because he doesn't have a key. So, what's going on here? What's the story here? And then they call the star witness, the lead detective, Detective Moretti. We know he doesn't look at the surveillance tapes on the various Miramar Parkway and Pines and what have you, because he knows. He's worked the area. He knows that he got 9807, the phone that Melly has used, and you've seen various and a lot of photographs. I think it's Exhibit 115, am I correct? 100, excuse me, 100. And who did they get this phone from? Detective Moretti. Jameson Francois. And certainly you asked him, how long have you had this phone? And he says, I never asked him. How convenient. And he goes and says there was another phone in the vehicle, but it was broken. That's 115. 115. So I can't tell you whose phone that is. Now, we don't have a burden to do anything. If you recall, we asked him to take out the SIM card of this broken phone. And there was a reason for it, to tell you the quality of the investigation. He took out that SIM card, read the serial number from that SIM card, which he had never done until you saw him open this phone in the courtroom. And he agreed that you can take that serial number to T-Mobile, Sprint, and what have you, and determine whose phone is, who is the owner, subscriber, and get a warrant for that phone. You've got warrants on a lot of phones. Get a warrant on that phone if you want to see what it is. Reddy doesn't want to do that because he's afraid. It'll ruin the investigation. That's why I put these two phones separate and apart from all this other stuff. Now, the state said to you, there was no reason, I think was the exact quote, for the Jeep to stop on the side of the road. I suggest to you that as we have done periodically through this case, the reason was
Again, ladies and gentlemen, this is argument. Proceed, counsel.
The reason was because he needed a bathroom break, just like you and I did when I raised my hand or stand up. And at 3 o'clock in the morning, 4 o'clock in the morning, if he needed a bathroom break, in the dark highway, and you saw him carry it in his hand, he'd leave it on the seat of the car. And we know that the car sped off because there was another car waiting, the red Mitsubishi. You want to know there's no reason? The poor kid had to urinate. And the phone was in the car, but they don't want you to know any of this. That's why we had to call Adrian Davis. But let's stay on Moretti for a little while. Because they execute a search warrant on his house, his apartment, and his storage unit. They find ammunition in there. They find in the storage unit, I think, 3 holsters and gun locks. We don't know what type of guns belong to those holsters. We don't know what type of guns were the gun locks to. All we know is there are 3 guns missing based upon the 3 holsters. And Moretti doesn't even ask where these weapons are. What are these weapons? Should it concern you? Yes. Should it show you a lack of evidence? Yes. Ask yourself. They keep telling you to use your common sense. Use your common sense, please. Ask yourself why a lead detective of a double homicide would not ask Jameson Francois, where the hell are the guns? Where the hell are the locks that belong to the guns? Where are they? I suggest to you when you use your common sense, you're going to say, he doesn't want to know. Because God forbid, those or one of those could be the murder weapon. And then the investigation of this rap star is down the tubes. He reads to you various messages from various people. But he never goes to talk to these people to see what they meant. You search Jameson Francois' car that supposedly is involved in taking Melly. And 4 months later, well, if you go and search his car, Jameson Francois, let's go back again to his house. Get up here, State, and tell him why you didn't search the house. You learn about Frito Bang, supposedly takes him somewhere. Why in the heck don't you search his house? Even if it's 4 months later, 5 months later, 10 months later, and use that fancy spray. Not the one that causes you to get sick, but the new spray. And look for it. What kind of investigation is this when we're talking about putting a young kid on death row or life without parole? Or any investigation? This is no game, folks. We're playing for all the marbles. That's why they said that Miramar Police Department lacks the training. They did absolutely nothing once they got that surveillance tape. Blinders. blinders on them. We're not going to look to the left. We're not going to look to the right. We're just going to direct everything to this young man. And I'm glad they admitted the suspects of 13. We know that Cortland Henry's involved. You heard about Crucial Almighty David Hedgepath, who wrote and texted, "We killed 2 of you." And someone said I should use the word ninjas instead of the word that he used. And in that message, he had a target over someone's face. Whose was it? Guess what? It's Melly. And he did it within hours. And what did they do? Nothing. Years later, they get his so-called timesheet where he was working. They don't bother to talk to any of his co-employees to verify this. In fact, if you look at the timesheets, it gives him time to, I think he's up in Verrill and Melbourne, to be exactly in Broward County, which is about 2 to 3 hours before the job. It's no alibi at all. But why don't you talk to these people? Why don't you investigate? How in the hell does he send out a text? "We killed 2 of you. We were aiming at the Jeep." Bentley, who had a problem with Melly, he does nothing. That's not a person of interest. He knows that there is a incident at Walmart where he's robbed of a chain, I think it is. Why don't you get the surveillance tape? Or at least try so you can say, "I tried," and it doesn't exist anymore. Jameson Francois with the missing guns. He's the manager who had, I think, $16 million in his account. If anyone had a motive in this case, it would be Jameson Francois, possibly. I don't know. We don't have to prove a darn thing. Why don't you at least investigate? Why don't you do the work that is required before you ask 12 of you to either put him on death row or life in prison? Jay Green, who had a beef with Melly. Why don't you check him out? Quando Wanda, why don't you check him out? Gina, who said he's going to be on a plate. They're going to kill him. Moretti just says, "I don't even know who the heck Gino is because no one told me." Herc says you got to communicate with us or you're going to pay the consequences. He doesn't know who Herc is. Coon, same thing. And then the state rests. They say, "Folks, we've presented you all the evidence." Well, that wasn't true. Because we had to call Adrian Davis. And you learned that Adrian Davis showed up in the state attorney's office and gave a sworn statement. They never told you this. We did. We don't have to do any of this. And Adrian Davis said, I told you, he got in the car. How do I know that? Because I was woken up when someone was crawling in the back seat. How do I know that? When we got to Melly's house, he's the one who had to open the door. Because only he and Cortland Henry had the key to his house. Why do we have to do that? Why did they conceal that from you? Why did they hide that from you? I can't answer those questions, folks, but I don't have to. Other than to say, reasonable doubt. You know, when we started this journey together, the state promised you that they were going to prove their case beyond the exclusion of every reasonable doubt. They told you that they have accepted the responsibility, that they have the burden of proof. They told you that they would prove each element of this case. What they have proved to you is that Cortland Henry is involved in this case. Who else, if anyone else, you folks don't know from the evidence. They tell you and play you a video where Melly appears in Cocoa Beach that afternoon. Well, as AD told you, there was a contract. People were going to lose a lot of money. And he happens to be at the tender age at that time of 19, a professional. And we all know, and unfortunately, probably a lot of us have had to do something while we are suffering an illness or a death in our family. What does that prove? Absolutely nothing, other than at the tender age of 19, this kid, I say kid, I shouldn't say that, this man, young adult, is a professional. They say because he didn't show up at 1 or 2 jobs, that what the heck? They have no idea what the contract was. They have no idea how much money was involved. They have absolutely no idea. Why? Because there was no investigation. Play this. And they want you to believe that he's a cold-hearted murderer. When quite to the contrary, you saw the tapes. You saw that he's a nice young man and a professional. Folks, the worst thing you lawyer can do is sit and see a misjustice, no matter what side of the fence you're on. Especially when you're talking about a 19, 23, 24-year-old kid. Man, young adult. To me, he's a kid. Because I have children older than him. The worst thing you can do is sit and see a misjustice. And we have sat here for months, starting in April, waiting to see the evidence. And I suggest to you right now, you should have more questions than when you were selected as jurors as to what really happened. And there was a gentleman who recently said that our system of justice is broken. I don't believe that. But he got on TV and it was all over national news saying, I think our system of justice is broken. If you want to do justice in this case, and you want to follow His Honor's instructions of proving, making the state prove their case beyond and to the exclusion of every reasonable doubt, you will go to the verdict form and check off count 1. We, the jury, find as follows to the defendant: not guilty. We, the jury, on count 2, find the defendant not guilty. You may think he might be involved. That's not enough. If you waver and vacillate, that's what reasonable doubt is all about. You want to make sure the justice system stays intact. There's only one just verdict based upon the evidence they present. And that is, state, we just can't rely upon this beyond to the exclusion of every reasonable doubt, because there is a lack of evidence, there is a conflict in the evidence, and the evidence itself, and the investigation itself stinks. I'd use another word, but I would probably get held in contempt. But I think you know what it is. So say we all.
Council, thank you. Then you're going to take a short recess. Case is not being turned over to deliberation at this time. Under the admonition, we're not discussing it. Opinion about the case, don't allow anyone to discuss the case in your presence, so there's no research, just leave notepads at your jury instructions on your chair, please. Thank you. The jury continues. Councilman Waller, do you rush and break? Yes, can we arrange that for Mr. Dennis?
Thank you.
Yeah. Discuss? No? All right, we're in recess. Thank you.